In view of the aforesaid facts and circumstances, this court is of the opinion that there is no merit in the appeal, and accordingly, the same is dismissed. Both the questions of law framed appeal are accordingly answered against the applicants and in favor of the respondent. I'll send back to you. In view of the aforesaid facts and circumstances and the discussions made, this court is of the opinion that no case for interference at this case has been able to be made out in these two decisions. According both the decisions are dismissed, interim orders stand effective.
May please alert you. In this case, Harish Gupta name is recorded. Instead of Harish Gupta, कुछ RKT A and A Gayan may record.
Whomever we have heard, we've given his.
Make please your lordship. My lord, I beg to mention item number 4, lordship. I applied for RTI, lordship. I need 3 weeks time, lordship. I need 3 weeks time, lordship, to get the record.
Case for dismissal.
Lordship, let me the reply of the RTI, lordship. I am ready to whatever.
You're buying some time.
Lordship, I am paying some time, lordship. 3 weeks time, maybe, lordship. I have a copy of the RTI.
What is inevitable? Let it happen today.
Lordship.
Deferring will not give you anything.
Lordship, if the RTI report, lordship, I may be allowed to get it, lordship, with all respect, lordship.
On
3 weeks time, maybe.
Muslim Learned Council for the petition. Matter is adjourned by 2 weeks.
It may be.
You have informed the health department.
Lordship, I will inform, lordship. It's a motion, lordship.
Motion or whatever.
Lordship.
Don't inform, will not allow it.
It may be 3 weeks, lordship.
Let the matter.
Wait, please, Lord. Can I have a motion on Monday, my lord? I filed yesterday.
Yes.
Transfer matter.
Motion matter.
I'm obliged.
May I please, Lord? My lord, I beg to mention a unlisted matter for listing my.
Motion.
No, my lord. Admission.
Admission. Why? Which matter? Which year?
My lord, the matter is, my lord, 2017, my lord.
17.
Yes.
Matter regarding what?
Matter regarding, my lord.
Okay, 17 matter next week we'll have. Next year, Wednesday.
Lordship, this order was passed by this court on 28th August. And after having the certified copy, I have noticed that some typological error occurred, minor typological error.
The disposal matter.
Disposed of. Accordingly, I filed an IA for the correction of the typological error. It may come up on Monday, Lordship.
Read petition.
Read petition.
What was the matter?
Matter was conversion from armed branch constable to unarmed branch constable.
Okay, oh, that matter.
Oh, yes, Lord.
Okay, it will be done in a chronological manner.
Yes.
What is the error?
Error that these petitioners are in armed branch. They want to be converted to the unarmed branch, and it has become the.
We'll have it Monday. Have you
Lord.
filed or not?
Yes, I have filed out.
Then Monday. Okay, Monday.
Lordship, I have another prayer for listing. It is a date petition regarding dismissal from service, admission, any date, Lordship.
For which year?
Of 2023.
23. No mention.
May I please, your lordship, I beg to mention one read petition for listing for orders, lordship.
Of which year?
23.
23 matter. Why do you mention it? It come on its own. What is the urgency?
Matter is relating to promotion, lord.
Mentioning is indulgence given only for urgent matters. Otherwise, listing is done by its own court case next.
May please, your lordship. Item 47 is a new matter.
Yes.
But it is wrongly come to the order.
It's a contempt matter.
Yes.
Contempt nowadays come under the orders. We'll have for
Pleasure.
May I please, your lord? I beg to mention item number 48, Lord.
48 years.
This matter has become infructuous, Lord. This is a contempt case, Lord. In the meantime, Lord, we got the benefit, Lord.
3 M. Ahmed Learned Council for the petitioner submit that the order dated so passed in WP
Has complied.
which is the subject matter of this contempt petition has been complied with, and accordingly he has instructions not to further press this petition. Contempt petition accordingly stands closed.
Highly applied.
May I please, Lord?
Okay.
My lord,
Yes.
item number 3, my lord. You have the instruction to withdraw this petition, my lord.
HMR totally.
Yes, ma'am.
Learned Council for the petitioner submit that he has instructions not to press this petition. Also heard M.S.M. Bhattacharya, learned additional senior grant exam. Petition is accordingly dismissed as not pressed. Yes.
Published.
May it please your lordship. I beg to mention item number 14. This matter is pertaining to bench 4, my lord, as we have challenged the award of the labor court.
Labor court.
Yes, my lord. In the roster, it was taken, my lord.
When award is under challenge,
Yes, the award.
it is submitted that the subject matter pertains to bench, civil bench court. Sarah, please free to verify and list for the appropriate bench. Item 14.
Deeply obliged, my lord.
Your lord,
Your airport
Airport.
is submitted by the airport.
May I believe your lordship?
Yes.
For listing lordship, I have filed 13/9/2023.
Hmm?
Motion matter lordship.
Motion matter.
Yes.
We'll have a 21.
Lordship.
Next Wednesday.
Simply.
Yes, Mr. Mazumdar.
Lordship, I.
Yes.
I
Please bring for some time. Item number
4, Lordship.
4.
I pray for 3 weeks, Lordship.
On
because
the
two
prayer of
weeks
Sri
will be
K. Mazumdar. No, Sri K. Mazumdar and counsel for the petition. Prays for some time to obtain certain information. Also had DP Bora, understanding council, health and safety welfare. Matter is accordingly done by 2 weeks.
I pray for 3 weeks, Lordship.
Motion 2 weeks.
obliged.
Well, please, your lordship. I beg to mention, lordship, for this matter of 2023, I am praying for listing this matter on Wednesday because it's a matter related to suspension matter. For last 1.5 years, he is under suspension without initiating a departmental proceeding.
You
Matter
are
was
receiving the subsistence allowance.
non-one.
You are not receiving subsistence allowance.
No, not yet receiving, my lord and my lord. Matter was listed on 16/5/2023. On the day, Honorable Court directed the State Council to open inspection, fixing on 26/5.
And the other one, which is the other matter?
My lord?
You said 2 matters.
No, one matter.
Okay, Friday next.
Your lordship, I beg to mention for listing of a case. The case was last posted on 28/7/2023. This is
Matter of which year?
23, ma'am.
What is the matter?
This is a transfer case.
Transfer matter.
Yes, sir.
You have an interim order.
Yes.
You have an interim in your favor.
Yes, sir.
Then what is your come on? Yes.
With the may to please your lordship, with the concern of the other side, I beg to mention item number 8, lordship.
8 years.
Matter may be adjourned for the day only.
What is your name?
My name is S.A. Khalifa. I'm praying on behalf of RD.
M.S.S.A. Khalifa, Senate Council appearing on instruction of the RD. Submit. Why adjourn?
My senior has some personal difficulty.
My lord, he informed me that he is out of state on matter.
M.S.S.A. Khalifa, Senate Council, submit that her senior RD, she is out of station. So also her DP. Matter is adjourned by a week.
Obliged.
Yes.
This matter pertains to the family pension. I recommend for admission matter. Any day next week.
Family pension.
Family
When did you file?
No, for admission matter.
When did you file?
2003.
Matter of which year?
2003.
23. When was it last?
Last dated on 16/8/2020. It was left over.
Come on its own family pension. Okay, next file.
Obliged.
My lord, with the liberty, my lord, what happened in this case? My lord, some of the parties which are not necessary, it has been implicated. A necessary party has not been.
As Dr. London Senior Council submit that there are certain formal defects in the petition, and therefore he submits that he may be allowed to withdraw the liberty to fight after. Taxation, anyone, water resource, taxation, Mr. P. Gogoi, P. Nayak. Mr. Nayak, are you for taxation?
No, taxation is not a necessary part.
No,
Finance is there.
no, they were made part.
Yes, my lord, is wrongly made part. That's the reason we are.
Mr. Chaudhary, is he there in the court?
Yes, Lord.
Are you a taxation counsel?
No, I am appearing for finance. Taxation is also a party. Both are party.
Also heard P. Nayak, understanding concept finance, semicolon, P. Chaudhary, understanding concept finance, written back and taxation, MS. M. Bhattacharya, state council, and water resource, J. Gogoi, and MS. J. Gogoi, understanding concept water resource department, who do not object to the state of error. Economic dismissed on withdrawal, liberty is paid for.
Much okay.
Yes. What are these matters, Mr. Bhuya?
My lord,
May I submit, my lord? What has happened, my lord? One of my matter, my lord, which has been, my lord, item number 55. This is exactly a new matter, my lord. We have even not filed the pleadings also, my lord, the affidavit. We are required to file an affidavit, but it has been tagged with some old matters on the request of my, my lord, friend, my lord. So, my lord, may I pray, my lord, that this matter, exactly a new matter, my lord, belongs to 2023, my lord. Can it be segregated, my lord, and maybe allowed to give the response also, my lord?
my lord,
What are these matters?
my lord,
They are challenging
my
the
lord,
certificate and validity of the B.Ed pass certificate, my lord, by the private respondents, my lord, and wherein they have said that the colleges and the institutions wherefrom we have passed out do not have the, my lord, my lord.
We had heard this matter.
yes,
My lord.
lordship.
Shashi Bhushan.
Yes, lordship.
May I submit, Lordship? In this particular case, Lordship has had the matter and fixed the matter on next day. Hereafter, Lordship, he has Purukashta has mentioned the matter in the another court. So case has been again tagged to that court. Thereafter, again, Lordship, we have made that it was heard and thereafter it was listed.
No,
But my
I
matter
think
has
he,
not been
Case may be, case may be separate.
No, my lord, it cannot be
Why not?
segregated.
It is a new
Because
case.
let me submit, my lord. His client has
No.
cheated my client, my lord, by obtaining, by suppressing the material facts, my lord. They have,
Mr. Purkasta, you may have the best case in the world, but without giving him an opportunity, we cannot.
they have taken time to file affidavit, but they have
we have
delayed.
taken-
My client is going to retire on 29th of this of next, my lord, February, and they are taking,
February.
yes. Yes, my lord.
Today is what?
For today, my lord, interim,
You are saying as if it is 29th of September.
no, my lord, interim,
Even if it is 29th of September, then also we can assure that we'll have it.
interim order, interim part will be considered, my lord, for timing, my lord.
No,
Interim, my lord,
we'll have to consider it separate.
yes, lord, interim,
Not today.
interim order may be taken into consideration, my lord.
Let him file the affidavit. When was notice issued?
Notice was issued by long back, my lord.
When?
1 month all over, my lord.
1 month.
Well, they have received the notice, they have
How can
appeared.
Yesterday we have disposed of matters of 2010. 3 matters of 2010, 2 matters of 2012.
My lord, what happened, my lord? He is holding the charge of the principal of the school without having the qualification. Number 1, my lord. Number 2, my lord, while submitting
Mr.
the,
Purkasta, these are in the realm of allegation. Without giving an opportunity, you may be correct. But currently required to give him an
he
opportunity.
is, yes, lordship, he is, for interim, it may be impugn order may be suspended, he may file affidavit, I will reply, my lord.
And only Mr. Bhuya is taking one month time. If you had been in this side, you could have taken 6 months time. Mr. Bhuya?
My lord. My lord, actually, the allegation which has been brought in, my lord, is absolutely.
Okay, you filed your affidavit.
My lord,
How
I can
soon-
find
how
it.
soon can you-
By 10 days time, may kindly be
A
given.
date may be fixed
When
after 10 days, my lord. This is the last chance.
Item number
He
55.
wanted to take over the charge by today, my lord. That is his intention. That is not.
He is
possible.
suppressed by qualification, my
No,
lord,
no.
and
You will take over as an auspicious, not today.
a date may be given, my lord, after within last chance for them to file the affidavit.
Heard P. Purkasta, the Learned Counsel for the petition. Also heard the Learned Counsel for the respondent. The A.R. Bhuya, Learned Counsel for respondent number 5, however, submit that he may be given some time to file the affidavit. Sarah? Since urgency has been expressed by on behalf, I would say to express on behalf of the petition, list this case on this, we'll have it on 28th,
Mal.
Thursday.
Mal.
Almost 2 weeks to file it.
My lord,
On
can
28th,
segregate my matter.
okay, 28th September 2023. The matter is not required to be listed along with the other matter.
Obligation.
And the other matters, why have it come to this? Why?
It is tagged, my lord, that's why it comes. It may come
Other matters, is it required for today or was the date fixed?
Pick another date, because the
56 to 59. Mr. Goswami, any date convenient?
5221 Loki has already heard the matter. Only reply was asked for from
No,
the
we'll have it today. There are many motions and all.
after motion.
Now, we possibly have it in a hearing day on Thursday next. 56 to 59. It is submitted that these matters can be taken up for final disposal. As agreed to by the parties, list for admission hearing on list on Thursday, under the column top of the list on which an endeavor will be made to dispose of the matter. This will be in 56 to 59.
59.
Why is Mr. Pathak sitting from the morning? Which matter? You have some
No
time.
interim prayer.
You have some time. You can go and have a cup of coffee.
My lord, I'll be obliged.
Don't be too
But-
late.
Coffee daytime, I don't take.
Whatever you want.
My lord.
Don't be too late.
My lord, I will come.
11
back. I will come. back.
latest.
May I please, Your Lordship, I may be allowed to withdraw this case, Lordship, with liberty. But, Lordship,
There's some mistake.
Lordship. Yes, sir.
When it comes to petition, submit that as there are some formal mistakes in the presentation of the one which of the written delivered to file a also heard some Bhattacharya and State Council, P. Nayak and the Standing Council Finance, and so for EG, what Dirabha, you are with somebody or are you a Standing Council? Yes, sir. Dirabha, the Council, yes, sir. Standing Council. Correct, it is according to this on required with report as paid.
Obliged, my lord.
May I please, your lordship? My lord, this matter has
Something
come up.
something was mentioned
My lord, my lord.
that we have taken some action in spite of.
peruse this particular communication.
Because I remember Mr. Hussain was
Mazumdar is mentioned.
making some mention that some action was taken.
My lord, they have, despite the interim order, my lord, they are initiating the process for the purpose of filling up of the post, my lord.
Not because you're covered.
My lord,
Your interest is protected.
Exactly, Lord.
my lord, the letter dated, my lord,
As per the instructions laid down in the interim, the order so
my lord,
of the court, institute will not fill up the vacant positions of junior assistant and senior assistant
my lord.
until the court gives the clearance.
No, that is correct, my lord. That is the communication made by to my learned friend, my lord.
We'll
but the-
record this.
Exactly, Lord.
My lord.
Record this thing.
We record this.
Yes,
Why
sir.
are you
Yes, sir.
apprehending?
Because
Yes,
this particular test has been conducted by the National Testing Agency, and this is not the NITs which are involved. Other NITs are also involved. So the process has been initiated.
my lord.
This matter was listed today on a mention made on behalf of the petitioner
Petitioner.
that uh, who had contended that in spite of the interim order dated 1/9/2020, a process was initiated for filling up the concerned post. Full stop. Correct? Sri S.P. Chaudhary, learned counsel for the NIT teacher, however, has placed before the court a written communication dated 14/9/2023, as per which, as per which, which clearly states that though the recruitment process is on, the same is being done without touching upon the aspect of the writ petition of the interim order, which pertains vacant positions, vacant pertains to post of junior assistant and senior assistant.
My lord.
The yes, madam, your for 1 and 5. Who's 1 and 5? You are sending your CCC. Take over your name and then Sharma. Also heard MS and Sharma learned counsel appearing on instruction of the K. Gogoi. Learned CCC. Mr. Gogoi has a stroke. Let her name be there. The matter according to stand. You have filed your affidavit, no?
I'm filing my affidavit.
Adjourn by 2 weeks to enable the respondents to file their affidavit. Copy of the communication dated 14/9/2020.
The interim order may be continued.
Interim order passed earlier. To continue to the next.
My lord. Obliged.
Can we fix the date?
Yes,
my lord.
Because otherwise,
Yes,
My lord. My lord.
please on
28, 29.
29.
My lord.
Or is it we'll have it done 4th of October.
4th of October.
My lord.
You get sufficient time.
Yes, sir.
And if you remember correctly, you said that decision was taken. Just convey the
Exactly, Lordship.
what is the decision?
Yes.
My lord, as per our-
We leave the embargo.
Yes.
My lord, as per my instruction, my lord, no, that decision has not yet been
No, let him
communicated. My lord.
put it on affidavit.
My lord.
That is why we are insisting on it.
My lord. Obliged.
Five years.
May I please well also, it's a compassionate appointment. His father was died in 25/10/2011. Thereafter, he had applied on 25/1/2012. But as the respondent authority delay in considering his application, he came before this honorable court and honorable by WPC number 503 of 2013. And this honorable court by judgment and order dated 5/3/2013 directed the respondent authority to consider his case and place before his case in DLC meeting. But in DLC meeting, they have considered his case but rejected on the ground that his application has spent its course, Your Lordship, as 2 years has gone by. That is the case, sir.
But unless you challenge the order of this court of 28/1/2021, how do you initiate a fresh challenge? Have you applied for review of the order? If at all you have some cause of action, you have to apply for review of 28/1/2021.
But Your Lordship, in in WPC number 6539 2006.
That is the WPC was dismissed
Yes.
on 28/1/2021.
Yes.
You say that it was dismissed in your absence
Yes, yes,
and holding the petition to be infructuous.
yes, sir.
Rightly or wrongly, there is an order of this court,
Yes, sir.
and the same cause of action you are trying to raise in this petition. Unless you
No, Your
get that
Lordship.
order clarified or reviewed,
No, Your Lordship. In that application, we have applied only to consider because till that they have not considered. But in that case, respondent authority came up with their affidavit that their case has been now considered and rejected. So that DLC meeting minutes were not been there in that writ petition. Your Lordship. Now we are challenging that minutes of the DLC meeting. Your Lordship.
That minutes was of 2016.
Yes.
How can you challenge the minutes of 2016 in 2020?
Because before that, this writ petition was filed. Your
It was
Lordship.
decided on 28/1/2021. What is your explanation from January 21 to September 23?
They did not communicate it with her, but we have
from
applied for
28/1/21. What are you doing now? If you say that it was not communicated on 14/6, at
we
least on 28/1/21 you came to know about the decision.
we did not know about the minutes of the meeting. Therefore, we applied RTI application to get the whole document, Your Lordship.
Mr. Counsel, you have stated that the second writ petition was dismissed on 28/1/21
Yes.
on the ground that minutes of meeting of 14/6/2016 was produced before the court.
Yes.
It was produced, assuming you are not aware, but at least on 28/1/21 you became aware of this meeting.
Yes, but
From
we did,
January 21 to 23 September, what were you doing?
but we did not have the copy of the minutes. Your
So you will
Lordship.
sit tight till 2 years.
During yes, Lordship, some time has been taken by the district.
What's your name?
You say, yeah.
This is your first case. Is this your first case you are moving in the High Court?
No, Your Lordship.
Then we'll discuss. You're unlucky. If this is the first case, not have this. Sorry. First, you say yes. Then it counts for petition. Also heard. PWD, anyone? Also heard. M. Bhattacharya. Then a traditional senior guard for the staff. And 3. M. Bhuya. Then it's counsel appearing for the public works department. Also, the claim in this petition pertains to, and the issue in this petition pertains to a claim for appointment on compassionate grounds. Full stop. Para. It is the case of the petitioner that his father, Daman Singh Ray, was a regular master role laborer in the office of the Assistant Executive Engineer, PWD, from Abhaypuri, who had died in harness on 25/10/2011. Full stop. The petitioner claims to have applied for appointment on compassionate grounds by submitting an application on 25/1/2012. Full stop. The same was followed by filing a writ petition being WPC 503 of 2013, which was disposed of by an order dated 5/3/2013 by directing testing of the matter before the DLC Bongaigaon. Full stop. As no information was forthcoming, the petitioner had filed another writ petition being WP 6539/2016. Full stop. The said petition came up for consideration on 28/1/2021 when the petitioner was not represented. Full stop. However, the court was apprised of the DLC apprised of the minutes of the DLC meeting dated 13/6/2013 and 14/6/2016, in which the petitioner's case was rejected. Full stop. The state rejection is the subject matter of challenge in the present writ. Stop that. The Sekia, the learned counsel for the petitioner, has submitted that the rejection has been made on irrelevant consideration, and therefore this petition is liable to be allowed with a direction for fresh consideration. Sarah, the aforesaid prayer has, however, been opposed by both MS Bhattacharya, the learned state counsel, as well as Sri Bhia, learned counsel for the department, by submitting that the grounds cited in the rejection order are relevant, which will not require any interference. It is also submitted that the earlier writ petition was decided when the earlier writ petition WP 6539 2016 was decided on 28/1/2021, the minutes of meeting was placed before this court, and unless the said order is modified, public review, the petitioner cannot maintain the present challenge. After hearing the part and on consideration of the materials on record, this court has noted that the death of the government servant was in September 2011. The entire objective of the scheme for appointment on compassionate ground, which is a deviation from the normal recruitment process, is to overcome the immediate crisis faced by a bereaved family on the death of the sole breadwinner. In the instant case, more than 12 years have passed from the state date. This court has also noticed that when the earlier writ petition 6539 2016 was considered on 28/1/2021, the impugned minutes of meeting dated 14/6/2016 was brought to light, and even if it is assumed that the petitioner was not earlier aware of such minutes, he became aware of the same at least on 28/1/2021. There is no explanation as to why the petitioner has taken time of more than 1 year, 8 months to thereafter file this present petition. In any case, this court has found favor in the submission made on behalf of the respondent that unless the order dated 28/1/2021 passed by the court is modified, the instant petition is not maintainable. In view of the above,
Lordship, regarding the election of my lord Kazi, my lord, the petitioner before
election
your
of
Kazi and marriage registry, Muslim marriage registry. Petitioner before your lordship was a Naib Kazi, my lord. He continued 2020 prior to death of his death of his father, my lord, who was the Kazi of that particular area, my lord. Now, my lord, from 39/2020, my lord.
the election has not been held.
No, election held, my lord. The list was forwarded before the respondent number one, my lord. But till date, my lord, they have not made any selection. Now, my lord, section 13 of the rule, my lord, there is
Yes,
a
sir.
provision, my lord.
Lordship, my lord, what happened, my lord? Kindly see the
Does he have any right for to crave this relief in the which has been done in
if the selection is made, lordship already been held. My lord, that this has been forwarded to the my lord IGR. And my lord, that the panel list already been submitted before the my lord the permanent committee. The permanent committee earlier, my lord, what happened, my lord, their terms has been over. My lord knew that permanent committee has been going to be constituted. My lord, whether it is constituted or not, I do not know, my lord. Let me take
you
instruction.
get instruction to issue a short notice.
Lord,
Third jail Laskar done it conflict.
My lord, represent my last, my lord, communication 23/5/2023, page 23, my lord. Rule 13, my lord.
No, we are issuing notice.
My lord.
Jail Laskar done it conflict for the petition. Full stop. It's the case of the petitioner. What is the Naib Qazi?
Naib Qazi appointed
he is
by the
assist-
Qazi, my
assist to the my lord, that Qazi, lord.
It is the case of the petitioner that he was appointed as a Naib Qazi NAI in the year 2006 and had continued till 2020. Full stop. His father, Tafazul Ali Laskar, was the Muslim marriage registrar and Qazi of Hailakandi, who had passed away on 30/9/2020, and the recruitment process was initiated for filling up the state vacancy, in which the petitioner was also one of the contenders. The grievance of the petitioner is non-finalization of the selection process. On the other hand, A. Henry, the Revenue Department has submitted that the process is on and only because of certain administrative change, there has been some delay. He otherwise submits that the petition is premature and there is no cause of action. Be that as may, that notice be issued, returnable on 4th of October. For
all the respondents, sir.
Prehending the learned standing council revenue department accepts notice on behalf of all the respondents.
My lord,
That extra copy of the served upon him by Monday.
My
Sentences shall not be a part for consideration of the representation. It to have been filed for the time.
my lord, 1 minute, my lord. Rule 13, my lord. There
We
is
are
a
not entering into the marriage. Let him take instructions.
then, my lord, this last communication 23/5/20
What is
issued by the Assistant Inspector General of Register to the district.
Temporary
Registrar.
arrangement, he was.
My lord, there is a provision itself in the rule 13, my lord. They can grant temporary license, my lord.
But
That
this
may
is
be
the
considered.
administrative, my lord,
That we cannot
that
grant a
lord
mandatory
cannot direct
injunction
to
of
any
towards
lord
the-
to
My
give
Let him
appointment to
take the
any
notice. This type
Obliged
of
to-
mandatory injunction.
The pendency shall not be barred to
Already-
consider this 23/5/20.
We have said representation. You consider that if otherwise is eligible.
Of like,
May I please, your lord. Lordships, this writ petition has been filed for consideration of compassionate appointment, lordships.
That-
Lordship, the father of the petitioner expired on 6/11/2015, lordship. And
2015.
6/11/2015, immediately on 1/12/2015, she filed a petition for compassionate appointment, lordship. And the DLC, lordship, that is at page 46, lordship. DLC by its meeting dated 1/3/2016, lordship. So consider the case of the petitioner at page 42, lordship, maybe perused, lordship. Case
No,
42.
it was rejected that you are underqualified or what?
No, Lordship, this is DLC. I'm referring to DLC, Lordship. DLC recommended my case. DLC stated the loan applicant Srimati Bidisha Bora has been recommended.
You don't need to read. DLC represented. Thereafter, what happened?
Yes, Lordship. Thereafter, in the year 2020, Lordship, the SLC was held up. In the SLC, my application was rejected, Lordship, assigning the ground that does not fall under 5% cadre, does not fall under 5% cadre strength and does not fulfill requisite education qualification law. And the does not fall under 5% cadre is a common observation given to other candidates also. And in my particular case, after inquiring, I have learned that the qualification was raised, Lordship. Had a notification, gazette notification published in the Lordship.
SLC rejection is of May 2020.
Yes, Lordship.
Thereafter, what have you done?
Yes, thereafter in the same year, I passed the BA examination.
What have you done?
Yes, I have filed a petition, Lordship, before the engineer, Lordship.
So, if you have obtained the qualification after the consideration, how do you find fault with the SLC's consideration?
Actually, Lordship, I filed.
See, you have obtained the graduation after the consideration.
After SLC law.
So, what is the fault? At that time, it's the fact that you are not a graduate.
At that time, I was not graduate. But while the DLC considered, I was unaware about the raising of the qualification, Lordship, and the DLC was also unaware. So, Lordship, subsequently, I have.
Whatever is the law will prevail if it is for graduation.
Definitely, Lordship.
Only because you do not know the DLC doesn't. Whoever knows the law has applied the law.
And Lordship, subsequently, an application was filed through to the superintending engineer and annexing my document, Lordship, that I have passed BA, and that was forwarded to the chief engineer.
Now, you have passed the BA after how many years of the death? That was the 15. You have
Yes,
passed
Lordship.
the BA when? After 8 years.
I have passed BA in 2020.
Now, the consideration will be after 8 years.
Lordship, I was relying on the DLC, Lordship.
If you do not
Lordship,
have
my
the-
humble
if
prayer
you-
at this stage is that,
You do not
that
have the
my
graduation, the qualification. But what about grade 4 post? Aren't you interested in grade 4 post?
actually I was entitled, but
Aren't you interested in grade 4? Will you,
Lordship,
will you serve in a grade 4 post?
yes, Lordship, we've given Lordship.
Yes. The compassionate appointment he cannot choose.
Yes,
It's
Lordship.
only for grade 3 and grade 4 post.
Sir.
He did not have the graduation, but he was certainly having the qualification to be considered for grade 4. He or she.
She, Lordship.
Then you could have at least made an endeavor to consider him for grade 3, grade 4.
As it was from the DLC Lordship, it was.
No, we are on a different tangent. We are not
Yes.
on the case of the petitioner.
No.
We would not like to go by his case that now he has procured his graduation, so you consider.
This is
He did not have graduation, so SLC cannot be found fault.
different.
You cannot find fault with the SLC. But SLC could have applied his mind that whatever qualification he had, was her case able to be considered for any other post in grade 4? That exercise perhaps you have not done.
But that also cadre strength.
No, see, 5% and qualification has to be on the same because he was considered for grade 3. Now in grade 4,
Okay, Lordship.
we'll issue notice. But the delay factor is there. Not
Yes,
your delay,
Lordship,
the
8
delay in
years.
ultimate consideration. 8 years. That is against you.
And Lordship, I was actually relying on the
Their
Lordship, the
Lordship on this
forwarding Lordship. The department forwarded my case. I was unaware, Lordship. So subsequently, I have qualified. And Lordship, my condition is very bad, Lordship.
You are not Jed Hussain. Are you Jed Hussain?
Yes, Lordship, I'm Jed.
What is your name?
Yes,
Third to Jed Hussain and counsel for the petitioner who has made a claim for appointment on compassionate grounds. It is the case of the petitioner that her father, Mrinal Bora, was working as a junior assistant in the office of the superintending engineer PH, Guwahati Circle, and had died in harness on 6/11/2015. the application of the petitioner for appointment on completion ground was recommended by the DL meeting dated 1/3/2015. However, the SLC in the meeting dated 14/5/2020 had rejected the case of the petition on two grounds, named lack of vacancy, which is 5% cadre strength, and not fulfilling requisite educational qualifications. The learned counsel has submitted that subsequent the petitioner has obtained her graduation, and the fact that recommendation was made by the DL gave the impression that the petitioner had met all the requisite qualifications. Sarah, though this court is not inclined to accept submission that that when a recommendation is made by the DL, it is incumbent upon SL to mechanically consider the case without examining the fulfillment of the eligibility criteria. This court is also of view that even with the existing qualification, whether any exercise was made to consider the case of the petition for appointment in any grade 4
Any grade 3 or grade post, actually considering on her qualification now.
notice issued returnable by 4 weeks. Additional PhD. I Colita. Learned Counsel representing the Public Health Engineering Department. Active person number 1 and 5.
I'm
Whereas-
Porter.
When
Porter.
that extra copy.
Lost.
So, what is
My lord, the petitioner was removed from service, my lord. And they said, the unauthorized absence, my lord, they overstayed the leave for about 614 days, my lord.
there was a DP held?
DP held, my lord. Well, the only thing is that he should
Did
have
you
considered immediately.
did you prefer an appeal?
Yes, we have preferred an appeal. Appeal was dismissed on the ground of delay, my lord.
Heard 3 and 4 Learned Counsel for the petition, who is aggrieved by an order of dismissal from service. Dismissal or removal?
Remove, my lord.
Of removal from service by the order dated on 19/5/2023 after a departmental
No,
inquiry.
Lordship, date is wrong, I think. 19/5/2021 it.
19/5/2021.
Yes, 19/5/2021.
So,
Inquiry. The departmental appeal has also been rejected. Paranac, the petitioner was a constable in the Assam police and was posted in 11th Assam Police Battalion, Dergaon, and the charge is of unauthorized. Issue rule returnable by 6 weeks. MS, M. Bhattacharya, learned for all the respondents.
Yes, Lordship.
Already. That extra copy of them. The United States Council shall also procure the original file of the department.
My lord, my name is on M.K. Boro, my lord. M. Boro is a different. M.K.
Okay.
I love last man.
K is very important for you. Yes.
May I please your lordship? May I please your lordship? Matter pertains to compassionate appointment, my lord. Petitioner father expired on 13/7/2000.
2000.
2008. my lord. After that, he had filed the application for taking compassionate appointment on 30/8/2000. my lord.
Thereafter,
DLC recommended his name on minutes dated 2/6/2006. Lord, nothing was forthcoming from SLC, so my lord, he approached the honorable court. My lord. So, honorable court rejected his prayer by observing that that DLC ought not to have recommended his name. But,
that order is of 2009.
Yes, ma'am.
And you have filed a representation 23. What is your name?
A. Gayan.
Is this your first case?
Yes.
First case.
Yes.
So no dismissal today. We'll give him a chance. We'll dismiss on another. But we will certainly dismiss you. So Goswami is smiling. First case. Some concession. Third, P. A. Gayan, learned counsel for the petition. But what is inevitable, let us do it today. Nothing to feel bad. Be a professional. Otherwise, you'll have sleepless nights. When is the dismissal come? Let it be. Third, P. A. Gayan, learned counsel for the petition, who has filed this writ petition with a claim for appointment on compassionate ground. It is the case of the petitioner, that his father, Sambhu Ram Das, who was working as a roller handyman in the PWD Rangia, had died in harness on 13/7/2000. The petitioner claims to have applied for appointment on compassionate ground, which was ultimately considered by the DLC in its meeting held on 2/6/2007. $2007 was the SLC or DLC?
2007 DLC.
Then when did SLC, when did it,
SLC has not recommended.
when, by which order?
SLC doesn't have given any any order.
Which
There
was
no
the
order. SLC
2/6/2007. Since thereafter, the petitioner had filed a writ petition being WP 3977 of 2008, as there was no further consideration by the SL of this court. However, by the order dated 10/6/2009, had rejected the prayer of the petition. However, with an observation that it be open for case respondents to consider candidature of petition if vacancy arises in future. The petitioner has failed to have filed a representation on 9/5/2020 and another representation on 11/5/2020 which have not been considered, and according to the written file, the Gayan the Learned Counsel for the petition has submitted that in view of the observation made by the court on 10/6/2009, the petitioner deserves consideration. On the other hand, MS M. Bhattacharya, learned additional senior so PWD, Assam, as well as the M. Bhuya, learned counsel represent Public Department, have submitted that the order of this court was of 2009 and the present case has been filed after about 14 years without there being any cogent explanation. They have also submitted that the present claim is not in consonance with the scheme for making appointment on compassionate grounds. The mode of offering appointment on compassionate grounds is a deviation from the normal recruitment process, wherein some benefits are given to the bereaved family who has lost the sole breadwinner to overcome the immediate crisis. Also, the death in the instant case was in the year 2000, and in the meantime, more than 13 years have passed. That apart, the earlier approach of the petition to this court was unsuccessful, wherein the writ petition was dismissed in the year 2009. Also, though there was an observation for future consideration, it is not explained as to what took more than 14 years. From the date of death, almost 20 years. No, almost 2023 years. That's the 8 years. 13 years to file a representation and thereafter approach this court. This court exercising powers under Article 26 is a court of equity, wherein the conduct of the party approaching this court is of paramount importance. And in this case, the facts and circumstances reveal lack of due diligence on the part of in that document. Court holds that there is no merit in this, and accordingly the same is not. The next case will allow. Mr. Sheikh.
In this case, my lord,
Another case. Yes, what is this matter?
well, they are the, my lord, initially they are the chainmen. They applied for the post of Mandal, my lord, in Deputy Commissioner Office, Morigaon. But thing is that, my lord, at the time of the advertisement, they have not passed, the results were not declared of the 6th. Now the result, they have applied it, but they said that they will not, this will not be considered. Well, in the
If you
advertisement,
do
my
not
lord,
have the certificate, how will you be considered?
My
That's
lord,
an
because-
essential requirement.
my lord, earlier this was my lord, rule that if-
Non-declaration of result is another part of the challenge. Only because you can challenge that why your results are not declared.
No,
But
man,
can you?
now results were declared, but after, my lord, filling of the form. So though we have applied, my lord, if you lordship go to page number 35, my lord, in the office of the deputy in Tachar, Silchar, my lord, there is a provision, my lord. Earlier
Yes,
also,
This is the one of the discretionary authority of the deputy commissioner. He can allow or he may not be.
now
allowed.
you have the this RCCC
I have.
They have been completed and my lord, that certificate already been issued.
third preemptive protocol concept for the petitioners who are aspired for upgradation of the post from chainman to
Mandal, they are not chairman now. They are working in my lord, Basundhara, my lord, on contractual basis.
as
Mandal.
Not Mandal, they are as the operators, my lord. As
who are presently working as operators
what's
on
that?
contractual basis under
Deputy Commissioner Morigaon, my lord.
for aspirants for the post of as operators under contractual basis under the Vasundhara scheme and aspire to be appointed in the post of Mandal.
Mandal, my lord.
So at the time of the recruitment, the petitioner did not have the RCCC certificate. What is the full form?
A recorder's class 4 certificate.
So we'll say RCCC.
RCCC.
Certificate is not to be wrong. Did not have the RCCC and therefore had earlier approved this court for declaration for a direction for declaration of results. In the meantime, the results have been declared, and in the case of the petitioner, that in
No,
certain
my lord.
other districts,
On the first time after declaration result, they failed, my lord. They again reappeared on 6th to 2003. Second term, my lord. Thereafter, my lord,
it is
the advert.
under the in the case of the petitioner, that when the results were declared, pursuant to order dated 23/11/2022, they were found to be unqualified. And however, in the subsequent examination held on 6/2/2023, they would clear the state exam. In the case of the petitioner, that similarly situated can have been given the benefit in other districts, and in this connection, reference has been made to a recruitment process in the district of Kachar. The petitioner praised for a similar treatment who hails from the district of Morigaon. That notice is returnable by 4 weeks. Three J. Hendrika, pending conflict 1 and December for 2 extra.
Well, in the interim, my lord, they are supposed to issue admit cards for written examination. So there may be allowed, my lord. Because they are in process of issuing admit cards for written examination.
The Board of the Learned Council placed for an interim order to the effect that they may be allowed to participate
My lord.
in the present recruitment. Allowed to, but present recruitment process. If the petitioners are found to have fulfilled the eligibility criteria, they may be allowed to participate in the state recruitment process by issuance of admit card.
My lord.
Yes.
Hello,
Just take what is it?
Lord, there was an advertisement for the post of TO1 and TO2. We are for TO1, my lord. And on 4/6/2023, there was interview.
You were selected.
We are selected, my lord.
Mr.
Appointment is not
My
made.
instruction from the executive engineer is that, my lord, there are the selection based on only Viva was the test, man. So there are so many allegations received, my lord. The entire process is under scrutiny.
Third, pre-MSc.
My lord,
We have not cancelled it, my lord. It is under
in the
scrutiny.
meantime, my lord, what happened, my lord, your lordship, if I pray at this stage, my lord, that my representation may be disposed of. I have filed a representation, my lord. Let
No,
them
unless
decide,
we are
my lord.
unless we are satisfied with your case,
My
we
lord,
will not act as a post office.
my lord. No, my lord, my humble submission.
No,
is
without
your
that
lordship.
response, we are not going to direct.
Your lordship, my learned friend said,
We can make an observation that penalty cannot be a bar,
fine, we were
but we are
given,
not going to dispose.
my lord. My lord, only my representation may be disposed of by them.
That will, but if that is your only prayer, we are not going to grant that prayer on the first,
My lord.
unless we have instruction.
No, my lord, that may be do. That may be done, my lord, by your lordship. Representation may be disposed of.
We will not pass a final order for disposal. We can say in the interim that there is no bar for consideration, but without instruction, that order will not.
No,
On
my
the
lord,
first day.
your lordship will see the representation.
No,
not
on the
based
first day,
on-
without the instructions, we are not going to pass something.
No, my lord, your lordship, everything. on
Whatever is
record.
there, without giving them a chance, we are not going to dispose
Everything
of.
on record, my lord, everything on record. And your lordship.
That is your projection, Mr. Sheikh.
My lord,
The first day we are taking up our case.
my lord.
We are not going to pass up an order, final order today, without giving them an opportunity.
My lord, my prayer before your lordship, their interview call letter, they are
Mr.
shortlisted.
Sheikh, we are not going to pass a final order.
No, my lord,
If you are
I'm-
insisting,
I'm
we'll dismiss
only,
this petition.
my lord, I am
We'll
only
see
for
that we'll give
disposal,
result.
disposal of the representation. my
No,
lord.
sorry, we'll dismiss this. We are not a post office. Sorry. If you are insisting, we are still giving you a chance. If you are insisting on disposal of your representation, we'll dismiss your without giving them a chance.
Then notice may come.
We are saying notice when we say given observation that pendency shall not be a bar. What more can you expect on a first? We do
For
not
this
know what is going on inside.
Tendency will
Not be a bar for representative consideration.
disposal of the
Yes,
representation.
that much we are saying.
Yes, my lord.
Third, the MS Senate concept for petitioners. So the petitioners claim to have been selected in a recruitment process for the post of technical officer 1
Yes, my lord.
under the Dhubri Public Health Engineering Division. And in this regard, a select list was also prepared on 9/6/2020. The petitioners have also filed a representation. On the other hand, Sri Goswami, you are appearing as AG,
As standing counsel, ma'am.
as standing counsel,
PhD.
PhD, appearing for the respondent,
I but for 6, my
has
lord.
submitted that instructions have been received as per which there has been gross anomaly in the recruitment process.
Allegation of anomaly.
Other instructions there has been anomalies
My
in
lord,
the
my learned friend
recruitment
submitted,
process
my lord,
which
my lord,
did not even consist
my lord,
of
my learned friend submitted that there are so many allegations. That the words of my learned friend may be put into record. What are the allegations?
and then consist of a written examination. Let notice be issued returnable by 4 weeks. Yes, all the respondents are
Six by my friend.
I'm
Yes.
preparing for response number 6. sir.
again present on but extra copy. Pendency of this writ petition shall not be about for consideration of the representation in accordance with law.
Representation, my lord, annexure 6.
Date,
Annexure 6, page 30.
date,
My lord.
date.
Date, my lord, it is received on 7/8/2023.
Received on 7/8. 7/8.
2023.
Oblige.
Oblige, your lordship.
Yes.
May please, your lordship, my lord, matter relates to dismissal from service, my lord.
As what?
My lord, allegation is marrying again, my lord.
As what?
He is constable, my lord.
Constable. Oh, charges?
My lord, marrying again, my
Hmm?
lord.
Second time marriage. DP was held.
DP was held, but the inquiry report was not furnished, my lord, and the act shows that
Third, Sri I. Chaudhary, Senate counsel for the petitioner who is aggrieved by an order dated
21/2020.
21,
2020.
2020 by which he has been dismissed from service. The petitioner was a constable in the Sasastra Seema Bal who was against whom a DP disciplinary proceeding was initiated. Full stop. The departmental appeal has also been rejected on what? How is not rejected? The petitioner has also claimed to have preferred a departmental appeal on 9/3/2020, which the outcome of which is not known to the petitioner. Issue rule returnable by 4 weeks, 6 weeks. Data for all.
Yes, my
Sri A.K. Datta Lanet, this is accept notice on behalf of all the responsible. That extra copy
Only the one thing
of the written served upon him by month.
one thing
On Sri Datta shall also procure the original record of the disciplinary. Yes.
I would like to submit that this petition was dismissed in the year 2020, and he passed, he preferred his petition after 3.5 years, my lord. But no, the petitioner has not explained the cause of delay.
Dismissal case, 3 years will not be that quick. Had it been some other thing, the dismissal case, we will examine.
Well, one very small typical error in the synopsis, my lord.
Synopsis, which one? Nowadays,
Date, my lord. In
date. Nowadays, it's not that easy. Everything is into CIS. Tell us which part.
My lord, in line number 4, my lord. The
First
date,
page. First page.
yes, my synopsis.
Yes.
It is the date is mentioned as 28/5/2020, between 19, my lord.
Okay. Give your details. In the pleadings, everything is okay.
Yes.
Make it in the copy of Mr. Raptol. Second copy and all the copies which will be serving, give it correct copy.
Lord, at this stage, my lord, notice may be issued because, my lord, I have relied on a decision of this honorable court, my lord, in 2022.
What is the case about?
Cases, my lord, I was appointed as, my lord, Anganwadi worker.
Okay.
And post of, my lord, Anganwadi helper, and post of Anganwadi worker fell vacant.
Okay.
due to, my lord, superannuation of the incumbent. Then I made an representation saying that in terms of the policy decision of the government, 25% post is reserved for, my lord, upgradation.
Correct.
And that was not considered. Then there was a, my lord, joint representation by the association. That was also not taken into consideration. In the meantime, that judgment, my lord, delivered by this noble court, that right to be upgraded may be a substantive right. Therefore, Lordship will examine this question at this stage, my lord, notice may be issued.
Third, PAK protest of Senate Council for the petitioner who has lost a claim for upgradation of her services from Anganwadi helper to Anganwadi worker in the 25% quota reserved for such upgradation. That notice be issued. Tenable by 4 weeks. Secretary for all.
Yes, Lordship, I'm for all.
All.
Obliged.
Extra copies.
My lord, my lord, my lord.
Chaudhary, what is this?
Yes, my lord, this is the matter relates to the regularization of the petitioners, my lord. The similar matter, my lord,
Regulation is what?
the regulation of their services, my lord.
As
Casual workers.
Casual worker, we are
What?
service.
can you be regularized
Yes, ma'am.
by without following the law laid down?
My lord, the similar other matters, my lord, are pending, my lord. And the notice is issued, my lord. This is the order, my lord.
Now, do you fulfill the requirement
Yes, my lord.
of paragraph 53?
Yes, my lord. We have fulfilled, my lord.
All the three requirements.
Yes, my lord.
Where you initial appointment was under a section post.
Not self-control.
Yeah.
Upenda's my lord, case will be governed.
My lord, we may be benefited of the Upendra show.
That's a different matter. But if you not fulfill paragraph 53, then you cannot claim regularization.
My lord, at this stage, my lord, some other all us. There are numbers of petitions before
We
this
cannot
court.
add to the litigation. Issues which were settled, we cannot reopen and add litigation. That issue has been settled by the division bench. Why should we entertain a writ petition only because of the fact that some other writ petition?
My lord, the matter may be heard, my lord.
No, if the issue is alive, if it has been settled.
Not my lord. The division bench judgment is different. My lord.
Then you tell us how you fulfilling paragraph 53 of Umadevi 3.
My lord, in this petition, he has not even annexed his appointment order, stating whether he has been appointed against a regularly sanctioned post. Illegal appointment, my lord, he was appointed also by incompetent authority.
Okay, we'll keep this one point open. Please to notice, file your affidavit with this. Third, P.H.R. Chaudhary, Learned Counsel for the petition. How many of you are there? One or more?
No, man, more, man.
In fact, my lord, some of his prayers were agitated in a similar writ petition, which was also
We are 7, man.
For the petitioners who claim regularization of their services. Most of the petitioners have projected that they were engaged as casual workers in the post of LDA, tax collector, peon in various Panchayat Raj institutions in the district of Karimganj. Period 1999 to 2005, and also came serving continuous at a fixed date. It is also submitted that their pay, which was in 4,500 per month, was enhanced the year 2020. The claim for regularization has, however, been objected to by and Senate Council appearing on behalf of PNRD Department. by submitting that the petitioners do not fulfill the requirement as laid down in the case of Madip reported to it. He further submits that even the appointment letters of the petition have not been annexed to the petition. Be that as it may, that notice is returnable by 4 weeks. The antique learned council access notice on behalf of number 1,
3 and 5,
1, 3 and 4. Yes, finance, anybody? Finance, the Nayak was there. Please inform Nayak where inform. Speak Nayak for number 2. Extra copies by Monday. We have recorded it. The point of mention of the statement is, however, kept open. Yes, ma'am. What is this?
My lord, the petitioner has not been appointed, my lord, as in Gaubura, my lord, presently it is Gramapuran, my lord. In spite of my lord being selected after my lord observing all due process
You
of
were
law.
selected.
Selected, my lord. Therefore, my lord, your lordship will find my selection list, my lord.
Third, CPK, the Senate Council, who is active by his non-appointment as Gaon Pradhan of charge number 13 of Borpeta Musa in the district of Borpeta. The petitioner claims to have been selected and other selected candidates have been appointed in different charges. Madam, please do note that notice be issued for yes, the revenue as the 1, 1 and 2 and 8 out of the 3, 4, 5 extra copies Monday.
My lord, can it be possible to give an interim observation till the next statement, return not to fill up this post?
You are selected, how will you fill up by another?
I have not been appointed, my lord.
Have you expressed any apprehension that somebody else will be appointed?
My lord, maybe.
Where have you expressed? Have you made any statement?
My lord, I have not made any instance, but earlier, my lord, there is some
If there is
instance.
no apprehension in the pleading, we cannot.
My lord.
And you will have the right to come forward, hesitate if somebody else is appointed.
My lord.
We do not know their case.
My lord.
Okay, next.
Obliged.
Mr. Gupta?
My lord, the petitioner, my lord, has filed an application praying for voluntary retirement, my lord, which has not been considered, my lord, by the authorities. My lord, the facts of the case is that, my lord, the petitioner was serving as a regular labor.
Okay.
My lord,
R.C.H. Gupta, learned counsel for the petition, who is aggrieved by non-consideration of his representation for allowing him to go on voluntary retirement.
my lord.
The petitioner is present serving as a regular labor in the office of the executive engineer, PWD,
My lord.
Nalbari Railroad Division. Issued, that notice be issued, returnable 4 weeks. PWD all
Yes, sir.
in a
But it's not a case of voluntary retirement, sir. If it is case of unauthorized.
No, we have paid.
Monday. Extra copies by Monday. Yes. Next.
As is your lordship, this is a case of compassionate appointment.
Death when
Lordship on 17/7/2007, the husband of the petitioner died in harness while serving as sub-engineer grade 2, lordship. Thereafter, the petitioner made an application and her application was forwarded on 19/3/2009, lordship, page 21, lordship.
yes, thereafter
Thereafter, lordship, nothing has been communicated till date, lordship.
from
But-
9 you are doing what?
Lordship, at
From
that time,
2009 to 2023, what were we doing?
Lordship, at that time, the petitioner had a minor daughter, Lordship. She was 5 years old, and Lordship, they had a plot of land that had to be sold for the treatment of her husband, Lordship.
That I understood from 2013 23, you could not have put a representation.
Lordship, we have approached, but they were denying they were told that.
Unfortunate case, we have to dismiss third MSC officer.
Lordship, at least some instruction.
Sorry. We are not giving any intelligence in compassionate appointment.
Because nothing has been communicated.
Nothing else, you should have come.
Lord.
From 2007, if you wait and sleep over your right,
Lord.
will a writ court be able to help you? Not at all. Third MSC Alternate Counsel for the petitioner, who by means of this petition has made a claim for compassionate appointment. Sarah, it is the case of the petitioner that her husband, Mrinal Sharma, who was serving as a staff engineer grade 2 in the PWD Rural Road Division, Corbett, had died in harness on 17/7/2007. Where is your application? The petitioner.
Application, I have not got, Lord. I have not annexed, Lord. I have not.
Date?
If date I don't have, but that was forwarded on 19/3/2009. That is
The petitioner claims to have applied for appointment on compassionate ground, which appears to have been forwarded by the office on 19/3/2009. Sarah, I'm a state officer, Senate Council for the petitioner. Both data lookers.
Both data.
There'll be confusion. What is your full name?
Any.
Is it a tenure?
Ananya.
That is also similar. You have to change your name by affix. Pronoun. Ani and Anand. Submit that till date. The petitioner has not been informed of any consideration of her case for appointment on compassionate ground, and therefore appropriate directions be issued by this court. For contra comma, MS Ananya Talukar,
4 and 5.
who is for one PWD, 3
1 and
PNAC, Standing Council PWD, as well as MS 8 Talukar and State Council submit and opposes the writ petition by submitting that there is the lack of due diligence on the part of the petitioner, who has waited for almost 13 years, for more than 13 years, to approach this court, and on the ground of delay itself, this writ petition is liable to dismiss. The scheme for appointment, for offering appointment on compassionate ground is a deviation from the normal recruitment process, wherein certain benefits are given to a bereaved family which has lost its sole breadwinner to overcome the immediate crisis. Issuing a direction for consideration of such appointment after a period of more than 15 years from date of death would not be in sync with the objective of the state scheme. Would further the conduct of the petition in approaching this court after more than 13 years from the date on which the application has been forwarded itself disentitled from an equity credit. According to sentence dismissal.
Much obliged. Nice.
Lord, in this case, I am led by Senior Advocate K. My Lord, the matter may be taken up after some time. Please don't lag the bits of
What is the matter?
Court number
Well,
12.
I am not praying for any interim relief. For the purpose of issuance of notice.
Now, what is the payment?
Matter, my lord, I have been sent out on compulsory retirement. The issue is they have a circular which lays down the parameters.
You are challenging that order of sending it for here. We'll admit this.
Only thing that's
If you want, we'll record the name of the Chaudhary for some other purpose.
And I will be grateful to him because I have to go out of Guwahati also.
No. He's not praying for many.
No, I am not asking for it.
Part B, KP Pathak Kanan Senior Counsel for the petitioner. The petitioner who was serving as a general manager of the FCI and posted in the regional office at Guwahati is aggrieved by an order dated 12/6/2023, whereby he has been sent on compulsory retirement. It is the case of the petitioner that the conditions precedent for issuing such order is absent, and therefore the state order is void ab initio and liable to be, and according liable interfere with the parent. That rule be issued, returnable by 6 weeks. Then we also heard Sri K. N. Chaudhary, Senior Counsel, assisted by Sri B. K. Singh, Standing Counsel, FCI. That rule be issued, returnable 6 weeks. B. K. Singh for all friends. No, we have nothing. He's not making an interim prayer.
Only notice, my lord.
No, we are admitting it.
Anyway, I got free from the other.
No, we have recorded your name for all purposes.
Vote was considered.
Purposes have been served. He wants to go early.
He'll have his lunch, my lord.
My
I
lord.
don't know what fish he has got for today.
No.
Friday is a vegetarian.
But you're a vegetarian.
Friday I am a complete non-veg, non. That means.
Friday is a big vegetarian.
But if he comes to my residence, my lord, that would be different.
May
I have an indulgence, my lord? তুমি যদি agree করা, আজকে ঢুকি, আমাদের সমাপতি প্ল্যান করতে তো পোস্ট অফিসে করি তুই। Instead
No,
of
compulsory retirement. We'll have it for hearing. Don't worry. We'll not delay this matter.
My lord, I'm obliged. Appearing with him is a real privilege.
Obliged.
Yes.
May I please, your lordship, here the petitioners are candidate in staff selection commission for recruitment of constable in Central Armed Police Forces.
You belong to unreserved category?
Yes, your lordship.
What is your grievance?
Grievance is that they have get the benefit of relaxation in height and stage under unreserved reserved category, but their marks have been more than the unreserved category.
You are not unreserved category. You said yes. You belong to which category?
I am
ST category.
ST category.
Okay.
So they
You have obtained your marks, which is more than the unreserved category,
Unreserved.
but
So
still you are
they-
not being offered the.
offered, yes.
You think yes.
Yes.
You think yes, current counsel for the petition who are aspirants in a recruitment process for the post of constable GD in Central Armed Police Forces within bracket CAF Footwear. In the state recruitment process initiated by the advertisement dated 21/7/2018, the petitioners who belong to the ST category had participated and had also availed the relaxation meant for the state category. However, it is the case of the petition that in spite of obtaining marks more than the last candidate in the unreserved category, they have not been offered appointment. That notice should all respondents,
Lord.
all respondents, copies Monday.
Lordship,
Please, Sharma.
last selected candidate of unreserved.
Last
Apply.
Yes, Betty.
May it please your lordship. My lord, the petitioner was appointed as the assistant secretary of number para Sakla SS Limited, your lordship, by resolution number, your lordship.
Yes.
Is at page 25 to 29, your lordship. So since some allegations are there against the secretary, your lordship, so therefore he is entrusted with the power, your lordship, so and assigned the duties to perform as an assistant secretary of the state Samavaya Samiti, your lordship. And accordingly, your lordship, pursuant to that.
See, aren't you an employee of the Samavaya Samiti Limited? We're appointed by the society.
Board of directors.
Then how is the rate maintained?
Because you lost some in respect to that some communication official
isn't this a private
communications are also there. Your lordship.
Private dispute. They would have
This is a
approved
private
this bill
dispute.
to their lordship.
Lordship, Annex 10 may kindly be looked into, lordship.
Page
Page 44, your lordship.
44.
44, your lordship.
Yes, please.
Because this is the apex authority, your lordship, of the Samavaya Samiti, your lordship. So I did approach there, your lordship. Eventually,
yes.
So your lordship.
So what is you have approached the authority? So
Lordship,
it will be
lordship,
maintainable.
but this authority till date no action has been taken, your lordship. Despite the fact, your lordship, from time to time some communications are also there to your lordship to continue.
We have serious doubts that you are.
Lordship.
It's a private dispute. How do you flood the writ court with matters of this kind? Civil courts are there to raise your dispute in the civil. Have you filed?
Because lordship, I have made the party because.
What does the state got to do?
Lordship.
What does the registrar do?
Lordship,
what does the state do?
Lordship may be allowed to. Lordship.
Your dispute is against the respondent number 7.
Lordship, since some charges were brought against me, as many as 5 charges are brought against me, lordship. So in order to verify these charges,
you cannot raise your dispute in a civil court. Is
No,
there any bar?
but lordship,
Are you left remediless? You're not left remediless. You have remedy in law.
But you
It's not a case that you are left with no remedy. You cannot approach the court. There is a right, there is a remedy, but remedy is not in the High Court.
Lordship, since an inquiry has been conducted against me, lordship.
By whom?
And by the chairman of the one-man committee of the Samavaya Samiti, lordship.
Chairman is whom? Is board part of the board of directors.
Chairman, you lordship, respondent number.
We'll have to mentionably point open.
Lordship.
Part 3. Diwan. A Diwan Learned Counsel for petitioner.
Respondent number 8,
who is aggrieved by the action by which aggrieved by an order dated 23/5/2023 by which he has been released from the assignment of assistant secretary of
Number Sakla
SS
Limited.
Samavaya Samiti in the district of Mayo. The petitioner has also claimed to have filed a representation dated 23/8/20 before the registrar of cooperative society, Assam, which has not been looked in court of law. On the other hand, the J. Portal standing on the corporation fund raises a preliminary objection on the maintainability of the litigation, as according to him, the dispute involved is the private dispute. That noted we should tenable by. Yes, you have 4, 1 to 6.
1, 2, 3, 5, and 6. 4 is PTC, Your Lordship.
PTC, anybody? Mr. Nayak? PTC? Mr. Rabha? Mr. Sari? Chaudhary?
Lordship, yes, 41 may kindly be brought in record, Your Lordship. Advertisement.
We have doubts in the
That has been issued by the
only
board of
maintain the
directors.
that board of directors, how can you say?
Section 38 specifically says that the board of directors has the power, Your Lordship, to appoint a secretary.
Anyone, please do standing on the petition of notice and they have responsible number?
4.
4.
I appear for 1, 2, 3, 5, and 6.
1, 2, 3, 5, and 4. Declared extra by Monday. That's the petition for service of notice. Upon receipt for 7, 8, and 9, registered for 7 by month.
And Annexer 9 may kindly state, Your Lordship.
The tentative is how capital. So there are up there for the
Of case 41, Annexer 9.
has made since the tentative of the itself an such decline.
On the earlier occasion, my lord, it was submitted that my lord, the petitioner, my lord, on several occasions, my lord, went to the office to inquire about the application that was submitted, and it was, my lord, informed to him that it was under process, my lord, and it was never communicated to the petitioner that, my lord, that the meeting held on 25th of October 2019 was, my lord, by the DLC, my lord, had rejected the case of the petitioner, my lord. And my lord, there is a judgment of the Supreme Court, while reported in 2001, 8 SEC 443, paragraph number 16, my lord.
What has been said?
My lord, it has been said that if an order has been passed, my lord, and not communicated to the party, my lord, it is not valid in the eye of the law, in the eye of law, my lord. My lord, in paragraph 16, my lord, bottom, my lord. An order passed but retained in file without being communicated to the plaintiff can have no force or authority whatsoever, and the same has no valid existence in the eye
Is
of
that an answer
law.
for your late approach to the court?
My lord,
You will wait.
there has been a delay of 4 years, but my lord, it was never communicated to the petitioner, my lord. And my lord, the delay, my lord.
From 17, your who had passed away?
My 17, the father passed
Father
away.
of the petitioner passed away.
Application was made within a period of 5 months, my lord. DLC rejected the case of the petitioner in October 2019, and my lord, till now, recently, my lord, 1 or 2 months back, my lord, the petitioner came to know that it was rejected. It was, my lord, it was told, my lord, again and again that the process is going on, my lord. And
Where have you stated, except in
My lord,
paragraph
paragraph
5,
my lord.
paragraph 5,
Yes,
one
my lord.
statement, that's not going to do.
And there is no written representation submitted by the petitioner, my lord. Otherwise, my lord, he went again and again.
Third, MSR Board of Senate Counsel for the petition, who by means of this application has made a claim for appointment on compassionate grounds. Sarah, the fact protected is that the father of the petitioner Abdul Haq Borbia was working as a chowkidar, grade 4 bracket, in Nilbagan sub-block under the office of the Jamuna Commanded Area Development Division, Education Department. Where is it?
My lord, ho jai, my lord.
No, where is the document?
My lord,
Where do you get the name?
so, my lord, on page 7, my lord, paragraph 5,
No, where is the document?
and next. The application has been mentioned, my lord.
Where?
My lord, page number.
What CAD means?
My lord.
What is the meaning of Jamuna Commanded Area Development?
Yes, my Jamuna.
Okay. Irrigation Department Hojai, and had died in harness on 8/1/2017. It's the case of the petitioner that his application was taken up by the district level committee, which by order date 25/10/2019 had rejected the recommendation. Also, the Learned Council has accordingly submitted, not accordingly, has submitted that such restriction is arbitrary and requires interference. Per contra, MS A. Talukdar, Learned State Council, per contra, the N. Upadhyay, Learned Standing Council,
1, 4, and 5.
Standing Council, Education Department, as well as MSA Talukdar, Learned State Council, submit that the rejection was of the year 2019 and the present application has been filed after almost 4 years. They also, the Learned Council for the respondents also submit that there is no proper explanation to the state delay of Para in a reply from MS Barua, the Learned Council for the petitioner has submitted that the rejection was not rejection of year 2009 was not conveyed to her, and this regard has placed reliance upon the case of so and so reported in which has been laid down. Which paragraph?
Paragraph 16, my
That
lord.
an order unless committed shall not take any effect. Sarah, while the rival contentions made on behalf parties have been duly considered, while there is no dispute with the proposition laid down in the case of cited by Learned Council for the petitioner, the pleading to that effect is lacking. Full stop. This court has noticed that that except for a wall statement made in paragraph 5 of the petition, there is no explanation regarding the delay in making the present challenge. Full stop. In any case, comma, the supported citation is not on the point of delay in approach a writ court, which is a court exercising equity jurisdiction. Full stop, para. The scheme for appointment on question ground is a deviation from and wherein so in the instant case, comma, the death of the government servant was in January 2007 and more than 6 years have passed, and therefore a direction for consideration, reconsideration would not in confidence the state of the above.
Doctor, one more aspect, my lord. In case of delay in lashes, my lord, I agree there has been a delay, my lord. But for delay, my lord, belated service related delay, my lord, there has to be continuous wrong, and there is an exception that it has to hamper a third party, my lord. In this case, it doesn't hamper any third party, my
It's
lord.
not a question of third party, it's a question of equity jurisdiction. Your conduct is very important.
Yes,
If you sleep over your rights, you have to keep on sleeping.
Deeply obliged.
Next.
Obliged, Lordship.
Yes.
May I please tell you? This matter relates to correction of age in the certificate issued by SEPA, my lord.
1975.
My lord,
Your certificate is of the year 1975,
75, my lord.
and you are yourself 63 years. You have declared yourself to be 63 years of age. How are you serving now? What is the age of superannuation?
65.
65.
Yeah,
Are
I'm
you,
not sure.
you are in a subdivisional medical officer.
Yes, my lord.
Your retirement age is 65.
I'm not sure, my lord. This
What
is
not sure? Sir Roy?
Yes, my lord.
Only for professors and medical professors, it means 65, not for all. Government council? Madam, what is the normal age of superannuation of a medical officer? 60, isn't it?
60, Lordship, and
No, only for professors.
officer, yes, Lord.
How are you serving 63 years? You have declared yourself to be 63.
yes, my lord. My birth, the date of birth is 1/1/1960.
You have already overstayed. Haven't you read the earlier order passed by this court?
I'm not seeking anything related to service, my lord, here. In this,
Oh, you are 63 years.
65. It is 60, yeah, it's 65, my lord.
Of what? SDJ of the subdivisional medical officer. When was it made 65?
I cannot show as of now any authority on this, but I have heard that it is made 65.
No, no, sir.
It is
Hearing will not do.
increased.
Madam,
For professor, Lord.
not for SD. From where are you making the statement, Mr. Sikar?
Some of my friends, they are serving up to
As what?
65 years.
As what?
As medical officer, my lord.
Medical officer?
Yes, my lord.
Maybe by
My lord,
extension.
MBBS, they are grade 1 medical officer.
It is increased, my
Yes, anybody from the health department? Health. Mr. Bora? What is the age of superannuation of subdivisional medical and health officer? Has it been announced to 65?
65.
65.
65.
They are in the same category as professors, assistant professors.
Yes, my lord, because of a scarcity of doctors, my lord.
Is it extension or is it the general increase announcement of date of superannuation?
My lord, that is the general rule for investor of doctors.
When, from when, since when? Gogo is here, take his help. Is it 65? From when?
Under the health.
From when?
Then exact date, my lord.
It was not 65.
So it was so far as the my lord, doctors are concerned, my lord, under the health certificate, like the superintendent in a civil hospital. Yes,
Like assistant professor.
yes, that my lord, no, in the medical college it is 70.
No, for
But
university and all.
Yes,
65.
yes, like that.
Now, you come to the marriage, then your certificate is of 75.
Yes, my lord.
How can you make a correction after 3 years?
Yeah, I made the application for correction within the period of limitation.
When?
My lord, it is in 2023, this year, my lord.
That is within the period of limitation.
Yes, as per the Supreme Court decision rendered in a recent case, where it is held that the limitation for making an application for correction of the age in certificate relating to perimetry provision of this CBSC.
You are making
my lord, is
your
held that-
application is not for correction in the service book.
No, my
It's
lord,
for
the
correction in the
certificate.
SEBA certificate.
Yes, certificate.
The rule says 3 years from the date of last examination.
But the Supreme Court decision is that it is the coterminous with the period of preservation of the records.
Hello, telling about the Trika of the case, is related
Yes.
to the name director.
Yes. Can I produce?
That is a different context.
Yes, my lord, different context.
No, my
The
lord.
CBSE case.
Yes,
my lord,
CBSC
CBSE.
case,
That is
the rule is perimetry, my lord. The observation, the
Regarding
decision
says
is
the
at page
particulars, my lord. Name.
at page 19, 192, paragraph. Page 610. This is the conclusion.
Dicta has a visit 610.
Yes.
Page
610.
192.
Paragraph 192 onward. 192 and 193. May I read out?
Yes.
Although we have discussed the broad issues canvassed before us, in ultimate analysis, the real dispute requiring resolution is about the nature of correction or change, as the case may be, permissible to be carried out by the CPSC at the instance of the student, including past student. As noted earlier, broadly, two situations would arise. The first is where incumbent wants correction in the certificate issued by the CPSC to be made consistent with the particulars mentioned in the school records. As we have held, there is no reason for the CBSE to turn down such request or attach any precondition except reasonable period of limitation. And keeping in mind the period for which the CBSE has to maintain its record under the extant regulations. While doing so, it can certainly insist for compliance of other conditions by the incumbent, as such as to file a sworn affidavit making necessary declaration and to indemnify the CBSE from any claim against it by third party because of such correction. The CBSE would be justified in insisting for surrender, return of the original certificate or duplicate original certificate, as the case may be, issued by it, or replacing it with a fresh.
Where is the regarding the limitation?
Yes, this next paragraph.
Paragraph?
Paragraph 193.3.
Yes.
Indeed, it would be open to the CBSE to reject the application in the event the period for preservation of official records under the extant regulations had expired, and no record of the candidate concerned is traceable or can be reconstructed.
Yes.
Only in that case.
Till when they are supposed to preserve the record?
They have digitized, and the record from 1964 is available with the CPSC, my lord. Yeah, so it is available with SEBA. And another point here.
Where have you stated?
Sorry,
where have you stated?
I haven't made a statement to that effect, but I have a news report that all the records have been digitized.
Have you challenged the rules of this?
Yes, my lord, I have a question.
Where?
The rule. On the ground station.
Let us see the reliefs. You're praying for. There's no such relief.
Yes.
Where
No,
are
in the relief I haven't taken. If your lordship allows, I will amend the prayer, or your lordship can modify.
Where is the ground?
At page 17, my lord.
17.
Yes. Paragraph subparagraph 2.
Yes.
The regulations for conduct of examination by the board are issued under section 24. So and so. So contemplates regulation to be made only for facilitating functioning of the board for purpose of carrying out the provision of the act. The regulations cannot be so framed as to deprive any applicant of the right of seeking.
You are
correction.
having taking a ground that the regulations are ultra virus on your own without there being a declaration.
This
And where is it that it is in the digitized?
so there is a news report that I have put on record, but
Not of it.
and there is another aspect to this. Man.
Report the news report. Yes, what you have, what
My lord, the digitization, I have to take exception, my lord, from I think 2015 or 16, my lord.
No, will it do away with the rules?
No, my
You
lord.
may take an action, take a step for digitizing, which has been done now for all the office purpose. But will it do away with the rules?
No.
Rules have to be amended
Yes.
or has to be challenged.
Yes, my lord, has to be challenged, my lord.
You take instructions.
Yes.
We still give him a chance. You also come prepared.
My lord.
You come prepared, we'll give another chance.
Yes, my lord. Another aspect is there that the Supreme Court in this judgment says the rule that is in force during the at the time of issuance of the certificate will be applicable. Here, my lord, this is at paragraph 175, 176 of this judgment, and here, my lord, this the rule notification.
So we'll have another. Let him take the instruction.
Yes. Okay, my lord.
People assert. Also heard B.K. Roy turning on SC. Both the council, however, clarified that the in the order dated 13/9/2020, this court made observation regarding the age of the petition was declared with 60 years. Both the learned counsel, both parties have submitted that the age of court is 65 years. Roy didn't pass for both Lasker and Roy, however, submit that some time to be afforded to take further instruction. Put the paradigm for most of on Friday next. Next Friday. You take this back, ticket. You place it on the next book.
Oblige.
Okay. So let's not take this paper back. Yes.
Yes, my lord, we are the casual workers, my lord, and have been working since 1995.
Where?
And under the establishment of District Commissioner Karimganj. My lord, kindly have a look, page 31.
Then what happened?
Then happened, my lord, we are paying our regularization since time to time, and thereafter our documents and all data have been sent by the Deputy Commissioner to the Finance Department. But the contention that we are entitled for open the judgment. However, till date, my lord, our regular, that was not considered, my lord. Page 31, my lord, district commissioner categorically reflected everything.
Yes,
Please see the page number 33.
33.
33, yes,
Yes.
chapter 9. Department has considered their prior laws.
Not considered.
Third para, as per available record, proposal in respect of the two incumbents, namely petitioners, were not received by the finance department. It is pertinent to mention is that finance department has in the meantime adopted sunset clause as per direction of the higher authority and with the approval of the finance honorable finance minister Assam and all administrative departments.
That was the lacuna from the part of the respondent. My lord.
Where is your challenge to this?
Yes,
4/8/2023?
Not
yes, we have challenged, man.
Where?
My lord, in the first line that impugned judgment,
Where is your prayer to set aside 4/8/2023?
page number 2, my lord, impugned do not dated.
Page number?
And the ground, my
What
lord,
ground?
in the prayer, my lord.
Yes, prayer.
That
If you are aggrieved by a wrongful consideration and you do not challenge the wrongful consideration, which according to you is wrongful, what relief can we grant? You have not even challenged it.
and we are seeking, my lord, that Upendra's judgment, my lord. That
Understood, but your
that-
matter has been considered and rejected on 4/8/2020. And if you are not challenging that 4/8/2020, can we grant any relief? And you have annexed this. If you have not known about this, then matter would have been different. It's a part of your petition. You withdraw this file of press. R3, HR. Chaudhary, Senate Council for petitioners who are seeking regularization of their service, which they are serving as rate for the services as casually referred, which they claim to have been serving from 1995 in office of the Deputy Commissioner.
Yes, sir. Yes, sir.
Karim. It, however, appears that by communication dated 4/8/2023 issued by Revenue Department, the cases of the petitioners were considered and rejected, and that communication, however, is not part of the challenge. Sri Chaudhary, Council, at this stage, submit that it be allowed to withdraw with the liberty to file after the proper. Also heard as Dr. Pending considered, but Nayak also appearing.
Yes, on the what?
Nayak and standing council finance and as a Bhattacharya what I can discuss on the with good estate. The Borua.
My lord, these petitioners associations are grade 3 employees, but they are working master role since 1493 NIP.
Same case.
Lord, only new conditions set, my lord. They are now 35 years of service. They will.
No, they order covering you all.
They order
504.
504.
We have it. That has been fixed. Third, three, M.J. Barua led counsel for the petitioners. Posts are similar.
Yes, my lord. Greatly post, senior, senior.
Yes, Mr. Junior assistant, senior.
Senior assistant, take this.
Also heard Sri S.P. Chaudhary, understanding counsel and I. Sri Chaudhary, understanding counsel, however, submit that the issue is identical to those one case to the issue raised in another writ petition WPC 5040 of 2023, which has been fixed on 4th of October. He also informed this court that there is an interim order which would also protect present petition.
The communication loss you have been.
And in this regard, he has placed on record a communication dated 4th.
Yes.
4th. Communication dated 20th.
Communication dated 14th of September.
14th of September, whereby the interim order passed by the court has been appears to be complied. Sarah, according to this case on 4th of October along with the which tells the
Yes, sir. The extra copies may be furnished to the
that's an extra copy of the writ. Or you can issue notice of motion and
exactly, Lordship.
That issue notice of motion returnable on 4th. For all?
Not for all, Lord. Union of India.
Union of India.
Represented by whom? Union of India Secretary to Education. Union of India CGC, madam.
P4.
As Barua. MS Barua for 1
and 5.
And 5. Testing agency.
Testing agency.
Barua.
Will not apply for. Will be applying for this Union of India.
No, testing agency is a part of the ministry, isn't it? No. Director General. 5 can take step. 5 can you take notice?
You can take notice. No, 5.
What about
in other matter, Lordship, the CGC has appeared for this national testing.
5, what about 5? Can take 1 and 5. And
2, 3, 4.
This one?
4,
10. Every hard free SP Chaudhary Senate Council for the caveat who has lost this caveat who are initiated by an advertisement dated 7/7 process in the NIT sector. The caveat would be hard. This court from past any court. Caveat then it's heard. Yes.
Matter regarding appointment arbitrator matter.
We are not objecting, my lord.
Yes, any you have decided on keyboard?
I just had a discussion with my friend. If Honorable Justice A.K. Goswami would be available, we are not sure on it. We've not approached him.
I think he is available for arbitration.
Another thing we have to agree on is the venue. Because the venue is not.
Yeah, arbitrator will.
Venue arbitrator. You don't have an issue having it at Guwahati itself?
Yes,
my lord.
Yes.
They are available here.
Heard. But why 11 is before us? Second 11. This is the assigned court. Yes, my lord.
Perhaps there's a notification. I'm not
Is
very
this the
sure.
sign code for 11? The Honorable Chief Justice has to make a sign
Yes, yes.
the power prerogative of Chief Justice.
Because the code
11,
9 is also taking up perhaps.
then why is it just we want? Good. Yeah, that- We'll pass the orders, but
Yes,
I get
my
a
lord.
normal should move for a single page. Third, you aspect that are also heard BD Jaka and responsible.
1, 3, and 4.
Who is two?
2 and 5, my lord. 14.823. This code had been.
My lord.
Have been deleted.
Expert, my lord.
No, my lord, the
Okay.
service has been deemed upon.
My lord.
1, 3, and 4.
2 and 5.
No, you have to 1,
1, 3, and 5. 4.
and they are parties to the agreement.
Yes, my lord.
This court by order
14.
dated 14/8/20 has deemed that service of Participant number 7 5 is also complete. Sarah, the present application has been filed under Section 11 of the Arbitration and Conciliation Act, 1996, as amended, for appointment of an arbitrator for resolution of the dispute between parties. The contesting parties, contesting still counsel for the contesting parties have broadly come to a consensus regarding resolution of dispute by an arbitrator in accordance with contractual provisions. Both Children's Council has also suggested the name of Honorable Mr. Justice Hussain, retired Chief Justice of Chhattisgarh High Court, to act as the arbitrator. There are plenty of efforts that have Honorable Mr. Justice appointed as the arbitrator to look into the dispute, to an arbitrator to for resolution of the in accordance that the parties approach standard arbitrator within a period of 2 weeks from today, whereafter, along with a copy of the order, whereafter the learned arbitrator would take charge of
Lord, will your lordship also record that we've agreed at Guwahati because the cold storage is in Borbetta agreement signed agreement was signed in.
both of you are there. Why should we record? Nobody is raising any dispute. Why would Mr. Goswami, Honorable Justice Goswami would like to go to work?
Obliged.
What is the dispute? Cold storage.
Yes, it's a partnership.
Partnership, my
Yeah,
lord.
Obliged.
My lord, this is an application for appointment of an arbitrator.
Yes,
My lord, what has happened? Similar matter had gone to Supreme Court against the order of a concurrent bench of this court, my lord.
Yes.
So in that, Justice Amitabh Roy has been appointed as an arbitrator. My lord. I have
Yes.
the order copy, my lord. So that similarly, that
You'd like to have the same arbitrator?
my lord.
My lord, the other matters which were before the Supreme Court, my lord, those are different matters, my lord.
Here the issue is, my lord, the dispute is not arbitrable. As
No, no,
per
my
the terms of the contract, my lord, and the clause 55(2), if the claim amount is more than 20% of the contract value, the dispute would not be arbitrable.
No, my lord, that is not the contingent, my lord. What happened? This is
Those cases are different.
no, no, my lord. What happened? 4 arbitration applications were filed, my lord.
Now, if we raising a dispute related to
Out of which, my lord,
we will resolve dispute unless you both of you consent to
Yes,
the
my lord.
appointment.
Less than 20%.
Unless the resolution is there, we cannot straight away.
there is a resolution, my lord.
No, resolution between
No.
consensus amongst
The
yourselves.
consensus is there, my lord. The Supreme Court is disposed of that application, arises out of the
Are you
arises
agree
out-
with the appointment? You said it's not
My
arbitrary.
lord, the appointment before the Supreme Court, my lord, the fact of 20% was not there. That was relating to the fact that, my lord, whether railway can appoint their own arbitrator from the retired railway employees. That was the issue before the Supreme Court. Here the fact of the
Whether a person interested can be appointed.
yes, that was the issue before the Honorable Supreme Court.
That has been decided.
No, my lord, matter was referred to larger bench.
Has it been
So, my
decided?
lord, the
No, has that issue been
not
decided?
been decided.
Not yet been decided.
Not been decided.
No, no, my lord, that is not the contingent, my lord. What happened? One order was passed by this honorable court. Against that order,
Here, both of you.
That
We'll
was-
file our affidavit. I filed the affidavit, my lord.
You filed.
No, my lord, we'll file a affidavit. I have received the instructions.
Let him file the affidavit.
That would be
also
better.
this arbitral tribunal has already been constituted.
No, if he is objecting,
My lord.
then we have to hear him.
My lord.
We may still accept your prayer.
My lord.
But without hearing him, we can it's not be proper.
My lord.
And you also try to pursue your convince your client that if they are not opposed to having this matter adjudicated by an arbitration, you only need a fair adjudication, isn't it?
My lord.
Whether it's by an arbitration or any other process, you need a fair adjudication.
My lord.
Since the dispute has been raised.
In fact, my lord, the agreement is the same agreement which was there before the Supreme Court. Same agreement.
The issue was different there, my lord. That was ordered under Article 142.
I have a that for the petition. Also heard the concerning of railways. Para this application made under section 11 of the Arbitration Conciliation Act 1996, amendment, a prayer has been made for appointment of an arbitrator for resolution of dispute. Sri Sahiwala, the learned counsel for the petitioner, has submitted that pertaining to a similar
Arising out of the same contract.
pertaining to the same contract, the Honorable Supreme Court, in the case of, give the number and name,
My lord.
has already appointed an arbitrator. On the other hand, each counsel for the railways has submitted that the issue in the matter put the Honorable Court is not similar. And he raises a further contention that when the amount involved in the dispute is more than 20%
of the value of the contract.
Such dispute would not fall within the ambit of arbitration. The counsel for the railways also submit that he would like to file an affidavit for which he prays for some time. List of the 3 weeks.
My lord, small prayer, my lord, a short date, because they have taken several times.
Yes, there is a matter of 2020. You find list on going to give a date, Mr. Seval. Today is 15. On 3rd of 4th of October, 3rd or 4th.
Third.
First, second is a holiday. Third is a Tuesday.
Third
of October. By which time the affidavit number is verified.
My lord, at least 1 week.
Yes.
1 week before they may serve us a copy, we'll file a reply.
You ensure that he will serve you at 10 o'clock On third.
My lord, that will be,
On third.
my lord. No, I don't think Learned Council other than will do that. We'll definitely. So that
No,
we
it will
get
be a bona fide letter, not to deprive you from anything.
absolutely.
So, the officer will not come for signing. Something will have, otherwise will happen. Okay, next.
Duty of lesson.
Mr. Ahmed, what is this?
My, we are the selected candidate of my lord. We are the selected candidate as per select list and it's page 20, my lord.
For selected for what?
Petitioner number 1 and 2 are were selected for the post of Anganwadi worker, my lord. And petition number 3 was selected for the post of Anganwadi helper, my lord. But all other selected candidates are
Yes,
appointed.
madam. File affidavit.
Lordship, we have not filed affidavit. Lordship, I require 2 weeks time, Lordship, because there was a public complaint, Lordship, and inquiry has been conducted.
Okay.
Yes, Lord.
Heard and Ahmed petitioner. Also heard submit on instruction that there were against the present and we would like to fight this after 3 weeks.
Lord.
To enable filing of
It may be fixed.
such affidavit in a position of this on 9th of October.
Lord.
Yes.
My lord.
No, you are not there at 10:30, 10:15.
Oh, my lord.
No indulgence like this. You're not present and doesn't declare. Doesn't pronounce.
It was just with regard to the returning of the original title deeds that was with the registry. Those could be returned, my lord.
You should have been present here.
My lord, I apologize, my lord.
What apology? It's been given in the book. Will try to incorporate. Give the list whatever is.
My lord.
Where the service of tenure is 5 years only, Lord. So this is there. He already has completed. He rendered his service with effect from 23rd May 2016 to 6th March 2022, Lord. Which is
His
more
tenure
than
is
the 5 years.
tenure is over.
It's over, Lord.
No.
This
My
is-
learned friend is taking to another direction. My tenure is over. But again, there was a village committee. Village committee selected me as the first preferential candidate. And so far this matter is concerned that only 5 years that is completed. Kindly see page 52.
Now what relief will you be entitled?
Yes, I am entitled because the second time there
You
are
can be appointed for a second time also.
second time for 45 years since kindly see page 52.
What is your age?
My present age 38 years.
38.
Yes.
Madam, the issue is with regard to
No,
the
he's
second recruitment process,
Lordship.
where he says that he was selected as the first.
Yes.
The first preference.
They kindly see their own affidavit page 50. Page 50. I am
50.
reading, my lord.
50.
Also the allegations against the former secretary means I. Page 50, kindly say.
50.
Yes, 50.
Yes.
Bottom may be
Paragraph?
my lord. Paragraph is not given, but bottom. Also,
yes,
the allegations against the former secretary, that means I am the former secretary,
yes,
of the Durgamari village party has been proved as false. In fact, the former president of Durgamari VDP, Jabatullah Sarkar, has alleged that his signature was falsely taken under pretense of information of a new village defense party.
You are reading page 50 paragraph?
Yes, last paragraph.
Paragraph 40, part of the affidavit.
It is the affidavit of the SP, man. Second affidavit SP dated 28 to 23.
Where is it?
Page 50 bottom and page 51 middle portion. 51 kindly see. For the post of president, of the new VDP, one name has been recommended by the people present in the meeting. However, for the post of secretary, two names, namely Naushad Ali.
Something is wrong with your page. Your
Can you see the second affidavit at SP? Dated 28 to 23. It is served to me on.
This is 29 July 22. This is affidavit.
Can you see the affidavit of the SP?
Second affidavit.
Second affidavit, Annexure A. Second page.
Yes.
Second page, can you see?
Second page. This is page 63.
Then may I read, my lord? For the post of president, for the
SP has filed one affidavit, one additional.
yes,
Yes, Lordship.
Now, where is additional affidavit? There is
yes, I
nothing.
am sorry. Can you
Additional
see?
affidavit, we have, minors has been produced,
And
Lordship,
in the affidavit,
of the public meeting.
Yes,
where in the affidavit, there is no such. Where are you? Which part are you referring? There is one affidavit by one Sapnonil Deka, dated 29 July 2022, and another additional affidavit by the same gentleman on 2nd of March 2023. Which one?
my lord, I have been supplied the on 28 to 23.
28 to 28. This is the additional affidavit.
Yes,
This is additional affidavit.
yes. 28 to 23 can. Then in that affidavit, Annexure A is annexed.
Yes, and agenda.
A second page may be seen. Annexure A, second page. For the post of Lordship has seen.
Yes, yes.
For the post of the
This is
new
page
VDP.
65.
uh,
Page 65.
One name has been recommended by the people present in the meeting. However, for the post of secretary, two names, namely Naushad Ali and Pierre Ali Sarkar, have been recommended.
What is your name?
Naushad Ali.
Lordship, I think updated instruction is required. What happened thereafter, Lordship?
Status quo is there. My lord, unnecessary 2020.
Because it's of February, Lordship, it has been referred.
February 2022.
Yes, Lordship.
22.
Yes,
More than a year has passed.
yes, Lordship.
1 year, 7 months.
And this affidavit is filed on 28
Because-
to 23.
If your Lordship, yes, Lordship, I'm not on
Unnecessary,
that.
my lord, they are
Lordship,
dragging time.
kindly-
My lord, court should not allow such types of priority. They are she is submitting beyond the record. My lord. His own record is saying, kindly see, I am reading on that paragraph. However, for the post of secretary, two names, namely Naushad Ali and Pierre Ali Sarkar, have been recommended by the people present in the meeting. The people present in the meeting, being unable to finally decide between the two,
Yes.
has requested the concerned officer in charge of Vidyapur outpost so-and-so to make the final selection between the two candidates, and he has also stated to have no objection to the final selection made by him. It was also undertaken in the meeting that decision of the OC, IC of the police station will be accepted by the people present in the meeting. As such, for that purpose, the OC and IC, after deliberation as per credibility between Pierre Ali and Naushad Ali, Mohammad Naushad Ali was selected as being more competent for the post of secretary Durgamari VDP. Therefore, the new VDP committee has been constituted as under. So my name was there, Secretary Naushad Ali. So it has been also endorsed by the OC.
Now, that is the resolution of the public meeting.
Public meeting, that is endorsed by OC and IC. IC Vidyapur Outpost, OC Bongaigaon PA. So when it is accepted, and now kindly see the
What
appointment
action
letter.
will be taken after this public meeting?
No, what they have appointed, my lord, there is no reason shown why my name has been dropped. Now kindly see the writ petition. Actually, my lord, this is perhaps political appointment has been made. Kindly see the selection, page 29, kindly see, of the writ petition.
29, yes.
29, Annexure 10. The following new committee of VDP under Bongaigaon PS have been in constitution and approved with the following new officials. So, Durgamari, VDP, Secretary, Pierre Ali Sarkar. No reason is shown. And whether the OCI and IC has recommended my name.
Now, what is the status? Who is holding the post of secretary?
At present, my lord, the post is, there is a status quo order passed by this Honorable High
And
Court.
who is presently holding?
Presently, my lord, perhaps the authority has managed some other persons because there is status quo order.
What is your explanation? If he was selected by the public meeting,
Lordship.
then why do you prefer PR early circular instead over the petition? There has to be some reason. What have you stated?
Lordship, there are also public complaint also, there,
Against
which
him.
we have stated in the affidavit.
No,
Against him.
my lord, that they have themselves said it is found false.
Where have you stated about public complaint?
Lordship, in the original affidavit, paragraph 8, Lordship.
8.
Yes, Lordship.
Please read.
Running page, Lordship, I don't have that.
No, don't need to running page.
Um,
Taken up.
No, that is found false, my lord. Their second
8,
affidavit.
Lordship.
Yes, please, paragraph 8. Do not fill it. Rest of it.
On the second part, Lordship, the Honorable MLA Bongaigaon LSC has forwarded the public complaint to the officer in charge of Bongaigaon PS and Thana level village defense officer submitted by Mohammad Mabutullah Sarkar and 10 other members of Durgamari VDP, Lordship.
No, your allegations have been stated before.
No, that is.
Page paragraph 8. Madam, your affidavit, page 5, paragraph 8.
Lordship, that's what,
As
Lordship.
regards, please read. That as regards.
Yes, there is a general public meeting held on
No,
so
no,
and
no.
so. This was,
Yes, meeting
Lordship.
held to select a new VDP of the rest
Yes,
of the
Lordship.
allegations are baseless and concocted. These are your allegations.
Yes, then the Lordship, it was complained to the Bongaigaon.
In their affidavit,
Yes, they are replying to your paragraph 6.
in their
paragraph-
additional affidavit, kindly see annexure A.
That we have seen.
Their
In the public-
allegations are found false.
After the public meeting, they have
The public
decided,
meeting, Lord.
No,
they have decided to give it to the other one.
no, the SP himself is saying the allegations are found false. What they want more? And people selected me, recommended me, IC recommended my name, OC recommended my name, but appointment has been given to other person without showing any reason. If there is allegation that should have been reflected in the order, so it is violation of principle of national justice. Every person knows this. When there is selection, and in merit, I am the first position holder. So if I have to be thrown out, there must be adequate reason.
Where is that allegations are found to be false? Where?
Yes, kindly see my lord, additional affidavit annexure A.
Yes.
Bottom kindly see. Last 4 lines. Also, the allegations against the former secretary of Durgamari Village Defense Party has been proved as false. So since 2022,
One second.
in this matter, my lord, the employment order may be set aside. The authority may be directed to appoint me, my lord, because I have been deprived for no legal reasons. As per whom of the, perhaps my learned friends about MLA, DT MLA is forwarding, MLA has forwarded the matter. But it was the authority who inquired the matter and found the matter false. So what for? And my lord, Supreme Court has said, objection should not be for the sake of objection. It must be reasonable, legal.
In that case, Lordship, the private respondent has to be heard, Lord, because the appointment.
He was served, he did
Yes,
not come.
Has he been served?
Yes, he was served, he did not come.
Because he is also a party to this petition,
Yes, party,
Lordship.
no doubt. We have made him party.
He has been made party and he has been made party. Has he been served on?
Yes, my lord, served. He has been served.
Yeah.
Actually, he is thinking that as I am getting benefit from the state authority, so I will also, in that manner, he is thinking.
If your Lordship.
And
wishes
it
to,
is also reflected in the court's order, perhaps, in some order.
Let us see. Fine, a maintainability question was also raised.
This is listed for admission. Man. Yes, yes, sir. 45 years working. My record is very good.
Was notice issued in this case.
One order of my Lord Justice Honorable Sri Bujar Burwa and another order is my Lord Justice Michael. Those two orders have reflected many things.
No, has notice been issued?
Notice we have taken steps on it kindly.
No, where is your step?
No, step.
Where was notice issued at all?
No, notice was issued.
From our record, it doesn't seem that notice has been issued.
Notice has not been issued.
Yes, Lord.
While issuing rule, there was no reflection of the step.
We have issued notice.
While granting the interim order on 26/2022, it was interim order was granted without issuing notice.
And that is true. But thereafter, it was served.
If notice is not issued, how will he be served?
May I see the record for a moment?
Madam, you also have a look at the record. There is
Yes,
an
Lord.
order. We can
But
tell you.
from our
We can
Chief
tell you.
Lordship, there is no mention of any issuing of any notice, Lord.
You see the order of 31/10/2022. Kindly note the date. Note the date, please.
The rule issued, Lord.
Yes, rule has been issued.
Yes, sir, Lord.
And there is no reflection that you need to
No,
take
Lord.
step.
Yes, Lord.
And earlier, there is no order of issuing notice.
All along, it has been request for Lordship receiving instruction.
I will both of there will be some application from
Regarding Lordship on the private respondent, Lord.
Yes.
Nothing is there.
No, it's not even finished.
Yes, Lord.
And while the admitting case by rule, no indication for service.
Yes, Lord. Yes, Lord.
Since Clarence Counsel was saying that he was served, maybe there is some
No.
indication.
Actually, that was perhaps the observation. However, my Lord may justice service may be ordered if that be so. But without notice, the case cannot come up to this stage. That is the
No, rule was issued.
rule.
Rule has been issued. That is why. But there has to be.
Justice service is short date.
Okay. Once it is-
Lordship has understand already the case. What is the case? Oh, sorry.
Madam, with direct issuance of the judgment, but he is relying upon the resolution in the public meeting, which gives an impression that the earlier litigation have been found to be not true.
I shall also
Number one.
obtain instruction
Number
on
two,
that.
he was among the two candidates, his candidature was preferred.
Yes,
And
Lord.
that meeting was also attended by the Vidapur and
Yes, Lord.
one more officer. Under those circumstances, why he preferred the other candidate?
But one indication is there, Lordship, in page 4 of our affidavit. I don't have the running page, Lordship, where Lordship, because he already has served more than 6 years, Lordship, that's why the private respondent has been given preference, Lordship. This is there. This is there.
But is this a condition that one must have?
Lordship, as per rule 19 of the some village defense rule, Lordship, 5 years term is there.
Yes,
This
that is one term.
specific.
This is
Yes,
the second
one
term.
term.
Is there any disqualification that the person who becomes one?
Lordship, I shall go through the rule again, Lordship, and
Since one person,
advise Lordship on the
one person, maybe Subhan Ali, he is working since last 45 years.
Petition, whereas state represented by addition senior government Bhattacharya. So, ruled was issued in case by order dated 31/10/2000. There was no direction for step as a result of the private respondent number 5. 5
Yes, Lordship.
is yet to be served. Let notice be issued. Let steps be taken for service of number 5 by registered deed. The Learned Council also prays for a liberty to serve notice by dusty.
Yes.
That according to this step by notice registered by liberty is granted also that justice service however such justice service is to be rooted through the registry of that the next state be found. Yes, tell us a bit.
That may be fixed in the
Will we have it on-
last part of September.
2 weeks. We'll have it on opening day of 4th of October.
Lord.
4th of October, prior to which date the petitioner is required to file an affidavit in proof of such justice. It is also made clear that its notice accompanies the justice of command. The next date fixed, that is 4/10/2020, be clearly reflected.
My lord,
Interim order passed.
May- yes.
To continue the next date.
No, I have another prayer. Kindly keep it as part heart.
Oh.
No, my lord, she's 22. If this case is running without any result, so this is also against the law.
No part.
For a minor matter, so many years,
The next day will take.
that may be kindly observed then. Kindly observe.
You first,
My lord, I have a better case unless I have been deprived. Lordship has seen.
you first serve this.
I definitely, unless I serve, then my
The
case.
moment we see you will remember the case. Nothing more permanent over there. Just like here. Madam, what is this?
Till date, Lordship, respondents have not filed any affidavit, Lord. They have not.
Notices have been. Notices issued or not?
Not. They have already accepted, Lordship. Can you see the last order 25/5/2022? The second. last, Lordship, today only.
Okay. Second time. First time it's coming after issuing notice.
Yes.
Why after almost more than a year? Why? Yes, your one handloom textile.
My lord, notice was issued, but maybe my friend has forgotten to was extra copies.
But there is no direction. It's okay, I will.
Without extra
Understand.
copies, my lord, it becomes very difficult to take instructions from the department.
Give extra.
So, okay.
Your notice was issued on 25/5/2022. It appears. No, 3, third, Lieutenant Standing Council of, but as well as it alluded at under State Council. Submit that extra copies have not furnished.
And
30
yes.
and the undertake of extra copies by Monday. List of the 3 for
My lord, on the last occasion, my lord had required me to find out who is his DDO.
DDO, right?
The DDO is, my lord, the district and session judge in the capacity as member MEC.
Member.
That's the instruction, my lord.
So what do you do? Tell us.
He is serving as a LDA at the.
What is the resolution?
My lord,
The affidavit says that because he was appointed against that post, so he cannot claim seniority. But my lord, what I find here is that the initial recruitment was one. Maybe by chance, he got that post. If that be the position, my lord, his seniority cannot be suppressed. There should be one seniority. And provided my friend has also said, they have got no connection with that post anymore. So in that
We'll
way,
clarify that whether the post was a post originally belonging to transport department, but make no difference.
No difference now,
in
my
reckoning the seniority.
lordship.
And he, for all purposes, this should be treated to be an employee of the
Same.
But we came third Senate count for the petition. Also, you can add that senior count for the phone numbers, one pin, whereas MSMP product Senate count, non-standing count as appeared for the transport. The advance of the petition is with regard to a gradation list in which his name does not appear. The projected case of the petition is that he was appointed as an LD assistant in the establishment of
District and Session Judge
the
Bongaigaon.
District and Session Judge Bongaigaon
Against
in the year 1999 by means of a recruitment process in which 6 numbers of candidates were appointed various posts. Incidentally, common the post in which the petitioner was appointed was originally created by the Transport Department of the Government of Assam by memo number CMV dot 222 9 135 dated 29 to 1996. Also, the respondent numbers 1 to have contested that since the post was originally created by the Transport Department of the name of the petitioner should not be placed in the seniority list under the establishment of the District and Session Judge Bongaigaon. The aforesaid was directly verified by the respective department. MS Bora, the London Transport Department, upon instruction, has sub that though the post was originally created by the Transport Department for all practical purposes, the post is being utilized by and there is no record in the department with regard to the state. However, the understanding has not denied existence of post which was created by the transport. The higher account has sub that the reason assigned for not including the name of the patient in the gradation list are relevant and urgent as post question originally belonged or was originally created by the transport department. The Senior Council has, however, taken instructions that the ETO in respect of petition is the F is Senior Council as under which the petitioner is present. That after hearing the party and on perusal of the material report, though it is a fact that the post which the petitioner was appointed in the year 1999 was originally created by the Transport Department, the petition has all along served in the establishment of this and present under MS in under MS the recruitment being one for 6 numbers of posts in the state establishment in which the post was one which was created by the Transport Department should not be reasonable at all to keep not to include the name of the petition in the petition under sub as stated above. There is no record in the Transport Department with regard to the services of the petitioner, and all these service records are the custom of the establishment of you have the petition is allowed by direct respondent more particularly district and judge to regard the petition as a regular employee under the establishment for the purpose of certain of their petition in accordance according to its intent, which is counted from the date of the aforesaid size of recast is the name of gradation in accordance according to the data period of 45 days from the date of receipt of a certified copy of order.
My lord, if required, one more fact, page 24, my lord. He was also confirmed by, like others, by the district council.
Yes, the senior council also points out that the confirmation of the petitioner in his service.
Let it be in his. Let it be in his.
You have
Oh, no,
pointed
no,
out.
no, it's a fact.
Your
It's
senior
a fact,
council,
my lord.
I have pointed out that the confirmation of services of the petition was also done by the orders
District
of the district and
much of it. My lord, I'll be for 1, 2, and 4.
Not 3.
No, not 3. 3 is government. My lord.
1 third.
3 will be by my friend. 3 Ananya Talukdar.
8 Talukdar. Or government of
5.
Much of
May, your lordship, may kindly fill
My
the
lord,
last
in
order
this-
dated
In this matter, I
12/9.
adjournment, my lord. My lord, we have to file affidavit. The conducting counsel, Mr. Upamanu, my lord, his father has been suffering from an attack, my lord.
Doesn't matter. We'll adjourn. When can you file it?
With 3 weeks, my lord.
How to be our Mr. Council for the petition? Put Sarah, P. DP Bora, Learned Training Council, Health and Safety Welfare Department, however, submit the concerned training council of the department, the woman could not be present due to some medical emergency. Sarah, not fair. The other is please for time to file affidavit of please after
Your
for
lordship,
filing affidavit of
your lordship, there is an interim order.
Interim order may be
Then we
continued.
continue, your lordship.
interim order past 30,
17.
extend it till the next date of yes, please do.
My lord, the petitioner was inflicted with,
Affidavit file.
yes, affidavit filed.
In fact, speaking order has been passed. So I have just brought the speaking order by way of affidavit. But I would like to lordship, take your lordship to page 34 of the.
What is the issue?
My lord, the issue was that the petitioner was inflicted with one punishment, that is, the punishment order, it has two parts.
DP.
My lord, yeah, no, DP, my lord, that was the issue. But initially we did not raise that. But subsequently, my lord, we approached before the honorable court asking our promotion.
Now, was there any department proceeding against you?
Departmental proceeding, my lord, as per lordship may come to page 28, my lord. Page 26, my lord. This was the, my lord, order whereby punishment was imposed, my lord. Here, my lord, no DP is mentioned, my lord. Only the suspension was, it was dropped and the punishment was inflicted, my lord.
No, aren't you aware that of any inquiry? Your petition, huh?
Yes, my lord, as
From
per,
the stage of suspension till the stage of imposition of the penalty, what had happened in the intervening case?
yes, my lord, no DP was there as per my instruction, my lord.
Have you, is it the pleaded case that no DP was there?
Actually, my lord,
Is it your pleaded case?
yes, in the meantime, my lord, some other development was there. That we initially did not challenge, my lord, before the honorable court. But subsequently, my lord, what happened? We filed one representation. That representation was not considered. It was so far, my lord, our promotion is concerned, my lord. It was filed in 2014, my lord, that annexed 4, my lord. While that was not considered, my lord, we approached before the honorable court asking our promotion. The honorable court has passed the direction, and it was left to the respondent authority. If I deserve, my lord, my promotion may be considered. So accordingly, they have considered my promotion as per direction of the honorable court. Thereafter, my lord, while my promotion was considered, my lord, I approached before the authority concerned that to consider the other part, because my 2 increment was also curtailed. And that part, to remove that part also, my lord, I approached before the authority. Then the authority did not consider. Then I approached before the honorable court. Honorable court passed an order. So, my lord, passed an speaking order by the respondent. Then, my lord, they passed the speaking order. And in the speaking order, my lord, that is the page annex 8, my lord. Page 34, my lord. By that speaking order, my lord, they have stated that how the promotion was considered, my lord, that is not in their knowledge, and they have even they have said that also, that why the promotion order, it was, my lord, not challenged before the authority, and all this ultimately by this new affidavit, my lord, while they pass another speaking order, thereby, my lord, they have left entire thing to the honorable court and the government, that if the court permits, they can consider that part, my lord, our grievance. My lord,
No, see, the speaking order, it appears to be rightly observed that the same authority cannot decrease the penalty. It's the prerogative of the appellate authority or maybe a review. But how can the same authority take a penalty, rightly or wrongly, has been inflicted?
yes,
Now, if this court interferes with such penalty, matter is different. But if you want, you can also attest the validity of the penalty for the appellate authority. This was not an appeal. It was not for the appellate authority. So the order passed by the executive engineer does not per se appears to be an illegal order. The order which appears to be passed with exercise of proper application of mind, judicious manner.
But my
How do you challenge this?
Lordship, if Lordship, your Lordship goes to buy this new speaking order, my lord.
Yes, we are having a look at that.
Yes, my lord.
19.8,
It is my lord at page
34,
India affidavit, my lord. India affidavit, my lord.
34. Is it
40, my lord.
19.8?
No, my lord, page 40 in the affidavit, my lord.
16 marks, Lord. Page 40, Lord.
Page 40, my lord, annexure A, my lord.
Yes.
My lord,
Positive engineer.
By the
Yes.
chief engineer.
Here, my lord, the may I read, my lord. The government imposed punishment by so number order dated 22/4/2010 upon so employee of the office of the executive engineer, Tihu Investigation Division so for curtailment of 2 numbers of increment and nullifying promotion in future as per provision of the Disciplinary and Appeal Law. The Honorable High Court passed order dated so in WC number to consider promotion in respect of Dilip Kolita to the post of junior assistant.
Conditions be put out on merit
My lord.
to have a direction of the High Court for consideration. You have to make out a case of merit.
Merit, my lord, it is my lord apparent that we did not bring those issues, my lord, that the punishment order was there, and my lord,
No, because
our
asked me the
promotion was
last
barred, my
part.
lord.
You are correct in content. Last part, they have said that unless the High Court says, we cannot. So for us to say that you need to be promoted, you need to make out a case. You can hear the parties, but
My lord, for promotion part, my lord, already court allowed it, my lord.
no, this part.
In
However, the punishment of curtailment of 2 instruments
Yes, Lord.
may be lifted subject to permission. If you make out a case for interference,
Yes.
the instrument part, the stoppage of instrument part can be took. Affidavit has been filed, pleadings are complete.
Yes, my lord.
You can address court whenever you. Next Thursday?
Yes.
Hard certificate of counsel for the petition. Also hard to further understanding of irrigation department to submit that a further speaking order has been passed on 16 March 2020, which has been put on record by way of an affidavit filed on 21/8/2020 by the respondent. As agreed to by the parties, this for admission hearing. Two matters.
For increment.
Not Thursday, for full matter.
Let it be after vacation.
This for admission hearing after 3 weeks. And the parties and the running council have submitted that matter can be taken up for 5 weeks.
Lord.
Please. Yes.
May
Yes,
please.
Deputy, your response?
Yes, Lord. We will file, Lord.
What is
However,
the
it appears.
what is the issue?
Well, the issue is, my lord, he was engaged as a master law worker since 1992.
Yes.
My lord, my lord, by certificate indicates that he's working since then.
Now, what's the issue? We
My
don't
lord,
need to
issue
say.
is that, my lord, he is
Here he is.
pursuing the authority. His
For what?
contemporary persons are regularized, but
The
excluding
issue is regularization of
regulation
the-
as master law worker.
Third year, the running council to submit that notice has been to Sarah P. Nayak, understanding of the however, praise for and it's
My
done.
lord. My
3
lord,
weeks
my
time.
friend has not received the instruction as yet, my lord.
3 weeks
My
to
lord.
obtain instructions, plus file affidavit.
My lord, my limited prayer is that
the matter may be disposed of at this stage, my lord, giving a direction to the authority to take decision on my
Let us
representation.
know that then petition. File a petition. Please get instruction.
My lord, 10 months about, my lord, relapse, my lord. And I am going to superannuate, my lord. My age will be
Yes, Lord, Upendra's judgment is already there and he is receiving minimum pay scale, Lord. That's
Wait,
Lordship, on the last occasion, Lordship had made a query regarding the notification dated 4/3/2023, Lordship. So,
You file
we have
affidavit.
received a notification. Lordship, the claim of the petitioner has been means could not be promoted, Lordship, as per the point number 9 of the guidelines, Lordship, of this guideline.
Yes, my lord. This the same submission was made in the last occasion, and an instruction was placed before the court.
Instruction we received earlier, Lordship. On basis of that instruction, Lordship made a
Okay,
query.
they are banking upon a notification of 2023 March.
Yes.
Where the clause 9.
Yes.
It has been laid down that promotion shall remain confined to the Anganwadi centers of the same revenue village.
Yes.
And as such, an Anganwadi helper of one revenue village or ward of a municipality or town cannot apply for promotion in the post that arises in the center following a different.
Yes, my lord. This is not correct. This same submission was made on the earlier occasion, and I had shown that this is not correct because the one of the posts advertised is in the area where I am living permanent in my bill. Kindly come to the page 26.
No, but are you applying for direct payment or are you applying under the
For promotion.
So if
Promotion under this 2013 notification.
So if you're paying for a consideration for promotion,
yes,
that means your present service as a company helper will be relevant. It is in another village.
Yes.
Will your residence, the place of residence make any difference? Your residence place would be relevant only if it's a direct recruitment.
My lord, there is a provision for policy for reservation of 25% of the post to be filled up by.
Understood, but
Yes.
So first you have to be eligible. Madam, you file the affidavit.
Lodge.
Put this on record. At least let him have a chance to say, rebut this.
Mine.
Part 3 all asserted and answer for the petition. The issue in this petition is with regard to promotion of petition from the post of Anganwadi helper to Anganwadi worker, for which there is a quota reserved of 25% of the full software. MS A. Talukdar, however, has placed a notification of the Social Welfare Department of Assam date 4/3/2013 and under guideline number and under the guideline in clause number 9, just laid down that promotion from the post of Anganwadi helper to the Anganwadi worker shall be confined to a particular Anganwadi center, or to confined to Anganwadi center of the same revenue village that the aforesaid can be put on record by way of an affidavit, for which 3 weeks time is granted. You take this back.
Nice, Lordship.
Obliged.
May it please your lord.
Yes.
My lord, the petitioner before Lordship is an Assam Police Service officer. My lord, a disciplinary proceeding was initiated against him. And my lord, the disciplinary proceeding ended in my lord in favor of the petition. There was a show cause notice, there was a regular inquiry, there was the inquiry report. Therefore, disciplinary authority passed an order saying that no, he cannot be.
Inquiry report was in your favor.
No. Inquiry report, there were some on some charges, my lord, there were findings against me. But nevertheless, disciplinary authority came to the finding that I should be absolved from the charge.
Disciplinary authority.
Yes, that order
Was in your
lordship will
favor.
get at page 38, my lord.
38. Yes.
Now, please come to the fourth subpara, my lord. Whereas having examined, as a lordship got it, whereas having examined all the statement of witnesses, it has been found that most of them have denied the charges leveled against Bhaskar Oza APS. In view of it is deemed fit by the disciplinary authority to drop the proceedings against the officer. Now, therefore, the governor of Assam is pleased to close the departmental proceeding against the Bhaskar Oza, the then deputy superintendent of police of Dhubri. Accordingly, departmental proceeding against Bhaskar Oza, the then deputy superintendent of police headquarters Dhubri, is thus disposed of. So, my lord, my proceeding against me was dropped. Now, on base of the same very charge, my lord, another disciplinary proceeding has been sought to be started, my lord, which we challenge, and there is an interim order operating.
Where is
Next page, my lord. If a lordship would kindly come to the first subpara. While you were posted as Deputy Superintendent of Police Dhubri, a case by Dhubri PS case so-and-so was registered against Anis Akhtab Momin, Principal so-and-so, and the case was endorsed to you for investigation of the case. During investigation of the case, one Ariful Islam, son of so-and-so, filed an affair against you, alleging that you demanded money from him, and the case was registered by Dhubri PS case number so-and-so under Section 7 of the Prevention of Corruption Act. In connection with this, a departmental proceeding was drawn up against you by dated so-and-so. The said departmental proceeding was disposed of by order dated 6/8/22. However, the inquiry officer in his inquiry report submitted by dated so-and-so mentioned that in your defense statement, you admitted to have received an envelope, but you stated that it contained a CD. Further, during examination by inquiry officer authority, you stated that CD was relevant to the case number so-and-so, of which you were the investigating officer. Also, during examination, you stated that you did not report about the receipt of the CD that is compacted in the case diary of Dhubri police case number 12. Being a member of a disciplined force and a responsible police officer, your above act shows a gross misconduct in discipline, conduct, and dereliction of duty. Hence, you are charged with misconduct, indiscipline, conduct, and dereliction. Well, where is the scope, my lord? Rightly or wrongly, my lord, there was a disciplinary proceeding. This charge was there. There was a full-fledged.
Was the earlier charge identical with this?
Exactly, my lord.
No, here they have taken.
Please come to page 37, my lord.
No,
The finding of
why we are asking you the question?
Yes.
Because was the last part of this paragraph you have just read.
Yes, my lord.
At page 39. It appears that they are trying to find fault with your action.
In not reporting.
In not reporting.
Yes. Now, my lord,
That is
kindly come.
something which they have tried.
Page 37.
37.
Yes.
Yes.
This is the inquiry officer's finding. Last para, my lord. After careful examination of all the statement of witnesses, it is proved that Bhaskar Oza, the then DSP headquarters Dhubri, has received an envelope from Ariful Islam through his so-and-so orderly Krishnanath. In his defense statement, Bhaskar Oza admitted to have received an envelope, but stated that it contained a compact disc. Further, during examination by inquiry authority, he stated that CD was relevant to case number so-and-so, of which he was the investigating officer. Also, during examination, he stated that he did not report about receipt of CD to his supervisory officer. Neither sees nor mention about it in the case. Same some issue.
It's a motor. But you see minutely,
Oh, sorry, madam. Yes.
it's a motor.
No, I heard. Yes, madam.
The present charge appears to be an offshoot. In substance, you may be correct to think that ultimately it boils down to the same charge. But if you come to the charge memo at page 24, the first so-called notice,
Yes, madam.
the charge ended in with an allegation of demand for money.
Hmm.
Now here the charge is that you have not handed over the case CD.
But that aspect of the is something like this, my lord. A man is kidnapped. An FIR is filed regarding my lord kidnapping. During custody, supposing the man is killed. Subsequently, my lord 302 is added. So naturally, my lord, FIR will not contain that. It is something like that. Now, during the course of investigation, this fact has emerged. And there was an occasion for the inquiry officer to go into that aspect of the matter. But there is a squarely covered case of this honorable court matter, apart from the Supreme Court cases, that second inquiry on the same charge is not permitted.
No, that is what we are trying to understand.
Lord will kindly
Whether-
appreciate from that point of view, my
Whether
lord.
it can be the same charge.
Yes. Charges were, evidence was laid. The inquiry officer had the occasion to pronounce on that, my lord.
Whether the last part of the inquiry officer's report
Yes.
at page 37,
Yes.
where he writes that under the circumstances above, the charges of gross misconduct in discipline on the part of
Has been proved. Yes.
Now, will it also include a misconduct for not handing over the
Exactly.
compact desk?
Exactly.
That
But then disciplinary authority, after having taken note of this, has passed an order at page 38. Whereas having examined all the statement of these witnesses, it has been found that most of them have denied the charges leveled against Bhaskar Oza. In view of the above, it is deemed fit by the disciplinary
that was
authority.
not the charge. I mean, yes, government would like to have some proper hearing. We have it on a hearing.
And my lord, in the affidavit,
Can you, if you, the point, the analogy which you tried to, do, if you can say something that,
yes,
that even an offshoot is,
yes,
which can be traced back to the original charge,
yes.
that then
In fact, my lord, in the affidavit, this
what
time,
we are just thinking about. See, if you go technically by the first charge, this was not a charge.
but nevertheless, a finding is recorded. By the
Finding
inquiry.
is recorded and that has not been accepted by the disciplinary authority.
Yes.
Whether non-acceptance should also include that part.
Exactly, my lord. Everything.
Because see, the last paragraph says that the charges of not proved. Now, this was not a charge. That is
No, that way lordship is correct. But my
if
lord,
you can make out a case that it also takes into its with this charge also.
yes.
Madam, have you followed?
Lordship, yes, that I'm.
Then kindly assist the court on Thursday or but
Next time.
next Thursday. What Thursday?
Or a 19th.
Thursday. Can we have it on 26 Tuesday? You're around on 20
Yes, I'm there.
for admission hearing? For the cases which of our High Court, Edward Borgohai and Molloy Pora, all those cases were another inquiry on the same chart.
Yes.
When the inquiry report was in the favor of the delinquent, disciplinary authority could have deferred, but he did not defer. He said do another inquiry. So court has said that you cannot keep on repeating unless results come in your favor.
My lord, according to me, the answer lies somewhere else as far as respondents are concerned. But the procedure they have adopted, that cannot withstand judicial. I'm not there to comment.
Yes, you're not there to advise them.
If they find,
Neither the court will advise them.
but the procedure they have adopted is certainly not correct. Molloy Bora is the case, my lord, where all these aspects were gone.
In this 71 case KRD,
Plus KRD.
okay. Third, in account for the also heard the issue involved has it been culminated or what? At the stage you had come.
No, my lord, there is a stay on the second.
Now, when did you come?
We
On the
approached this
issuance of
honorable court on 18/1/23.
Why? At the issuance of this notice itself.
Yes.
The issue involved disciplinary proceedings initiated by a so-called notice. The case projected that the same charges were the subject matter of a disciplinary proceeding which had culminated in an order of exoneration. And thereafter, the impugned proceeding was initiated. This court, by order date, order date, 18/1/2020 had passed an order of age, which is the matter for some deliberation. This for admission hearing on a date agreed to by the party as 26 April.
May it please your lordship. In a promotional exercise by the authorities, respondent authorities, the Airports Authority of India.
Yes. Yes.
Circulars are being issued by the authorities time and again.
You work as what?
It's for the post of senior assistant operations. Senior assistant operations. The circulars are issued time and again, and they specify the experience and the qualifications required. That's standard and constant. In 2021, when they came up with a circular page 17, they specified educational qualification to be at page 17. I just briefly, without even going to that, graduate with LMV license and diploma in management with 2 years experience in the concerned discipline. I applied at that point of time, and at page 19, the officers concerned, the authorities concerned, had categorically given a certificate that, if I may read that part, that will be relevant, page 19. Certified that the above particulars have been verified from the service record of the above official, and the same is found correct, thereby
fulfill the eligibility criteria.
Yes.
It is certified that no disciplinary vigilance case is either pending or
Wait,
contemplated.
wait.
Page 19. Page 19.
Yes, wait.
So therefore, for the year 2021, I meet the educational and the all experience criteria as specified at page 17. 17, they say graduate with LMV license, diploma in management and experience 2 years. Page 19, the authorities give a clean sheet to me that yes, I fulfill the eligibility criteria. Are we on the same page?
One.
Lordship. Now in
Just a-
22, my lord.
You applied on the very next date.
Lordship. No, we are not on this.
No. You just
My lord.
applied on the very next
Lordship.
date. 13.7 was the circular.
14.7 I applied. And they issued that I fulfill the eligibility criteria.
Right.
I invite my lord's attention to the eligibility criteria at page 17.
Right.
Graduate with LMV license, diploma in management will be preferred.
Yes. Now
And
what
2
is
years
it?
experience. Now, page 20, in the year 2022, again they float a circular for the same promotion, Group C, Group D, my lord.
That time it was not, you were not
I was left out.
left out.
I was left out from the consideration. Although a year earlier, they find me eligible, a year later, they leave me out. I write to the authorities, I come to the court eventually. Their silence strikes hard. And this honorable court was pleased to provide that one post be kept in their 5 posts. Now they have
In
come
this proceeding.
in this proceeding. Now they have come up, eventually they have recruited someone, but one post is there. I'm not against that person. He went his way. Now they come up with an affidavit and they take a stand. One in my favor, one against me. The one in my favor is that in their affidavit, in the last page, just the last line, if I read out, it says that I have performed key role in GIP and all things coordinations.
What is it again? What is it again?
Against, they say that prior to joining Airports Authority of India, I ought to have had experience at page 53.
Experience in what?
Whatever they seek for. But a year earlier, they say everything is okay with me. Page 53, if I may read below. Third line. However,
Pages are not telling.
no, this is the service affidavit filed by my friend, the Airports Authority of India. 53 much, it's a continuation of the pagination.
Between an opposition by responsibility.
Mal.
Niranjan Talukdar.
128. 128. 128.
Not by Niranjan Talukdar.
This is Alitha Doren Lalu.
Yes, it starts at 72.
I mean, it is my copy. Even the pagination is there. Anyways, if I may read out paragraph 2, paragraph.
Private respondent has filed the affidavit earlier than us, that's why but we have taken note of the repetition.
Okay, now
Paragraph 4.
4 of
Paragraph 4 of that affidavit which they have filed,
internal page.
Internal page would be, if I'm referring to 1, 2, 3, 4, 5. Lordship may take the 5th page from the index onward. It starts with the word N.
Page paragraph 4 has got many subparagraphs.
Yes. Paragraph 4 has subparagraphs. I'm referring to page number 5, which has the relevant part.
No, 4 of which subparagraph 4?
4.1.
4.1, yes.
As it process over to the next page.
Yes.
I'm not on that, no, the next page.
Next page. However,
while issuing orders for inviting application for Group C and also for Group D, the intent of calling application is that they might have had relevant experience in the past before joining Airports Authority of India and to give an opportunity to apply for the post of senior assistant, which is direct recruitment post, but no relaxation is allowed in requisite qualification and relevant experience. This does not fit the whole. This is something beyond that. On the face of it, it's not tenable. All I pray is that consider me departmentally. On the face of it.
What are the grounds of not considering?
Basically, my lord,
What do you require? Tell us first. As per the advertisement, what is the requirement?
But he should have worked under the operations, my lord. That is the requirement. But and
How many years?
2 years, my lord.
Did he have the experience of 2 years?
Lord, what we are saying, Lord, that the scope of the work or the operations which are required, Lord, he has not done it.
No. Does he meet the experience criteria?
No, that is where, Lord,
What he has done, what has not done, we are not too much concerned. We are concerned whether he meets the requirement as per the advertisement. Now we cannot qualify your requirement.
Lord,
after.
that's Lord,
Whatever you have stated, you have spoken.
yes, yes. Lord, so
No,
far as my lord has
Obviously,
seen
you,
this,
obviously you will not take a person who is not eligible. Therefore, you have given the eligibility criteria in the advertisement. You cannot return and say, no,
No,
this,
no,
this
that's true,
man,
Lord,
this,
that's true.
not this.
Lord,
If
perhaps,
we substantially meet, consider him. This explanation of yours that is,
Lord, I understand, Lord.
that doesn't appear to be a very solid kind of.
No, Lord, Lord, I also agree to that extent because of being an officer of the
No,
court.
we are not
But it can't be
recording
something beyond.
recording any concession of yours. You have done what you instructed by your clients, but does not appear to be a very solid kind of a defense.
My lord, if your lordship would see at internal page 6, my lord, Roman 7. That is basically what, my lord,
In fact, to be very frank, we have not understood your ground of vision.
my lord, if
No,
I
but they
can,
had me qualified a
We
year
cannot-
earlier and a
we
year
cannot-
later.
We cannot term this to be cryptic also because you have given many expressions, but ultimately doesn't make out any meaning.
my lord, what I could gather is, my lord,
Have you understood?
yes, I have tried to, my lord.
You have tried.
Yes,
Have you?
to some extent, my lord.
Some.
Yes, my lord, if I can capitulate
But
it,
we have not understood.
my lord,
We have not
my
understood.
lord, I'll try to persuade your lordship to understand in the
If
manner.
you have not understood completely, then there is no question of persuading us.
No, my
First
lord,
we have to understand, be convinced, then you try to convince. Otherwise, let us pass here.
what it reflects is under operations you have bundles of works, my lord.
One post is vacant.
Yes.
Yes, that has been.
And orders of the. And I'm the only one left out. None other than
Do
supposed
you
to.
have any other problem with him?
No.
But experience is the issue, my lord. Otherwise,
No, they have given me a clean sheet a year earlier with the same experience. Can they hold me back a year later?
He has brown hair or what?
No, they're pulling the rein. They're pulling the reins, fellow.
You
That's
have-
the
You have brown hair.
maybe.
He's not handsome
And not blue-eyed.
and not blue eyed.
And not blue-eyed.
but I have heard my friend saying something which he cannot say now, my lord. Few years back.
Heard. He has chronic planet count. But after 2 days, there is any concept.
Yes, my lord, 128, my lord, I'm there.
Any concept. Airport
Ninth
authority of
and
the issue involved is a promotional exercise for post of senior assistant.
Yes, operations NE6.
But can I take one? But generally these posts are made for direct recruitment, Lord. But under the regulations, Lord, there is a scope where departmental opportunities are provided. Under this scheme of things, Lord, these posts are advertised.
But they have exploded.
Yes, that's my
We'll
only
record.
clarify.
We'll record. Vacancies in the grade of senior assistant, which is vacant capital and capital E 6 level through our department examination, which was published. And in this regard, a circular was published on 3/2/2020 advertised the notification five numbers of post of senior assistant certificate offered. The state circular had also indicated the educational qualification and it's the case of the petition that he having fulfilled the eligibility criteria had offered his candidate. However, since no intimation was made available from us, he had made a representation. After a certain period, the petitioner could learn that certain candidates were shortlisted for the state department examination. That reporting the learned counsel for petitioner has submitted that though promotion may not be a matter of right, a fair consideration is certain a matter of right from which the petitioner sought to exclude. He submits that no reason where other submits that the petitioner was not informed by any reason regarding rejection of candidature, in spite of the fact that he had fulfilled all the requisite criteria. By drawing the attention of the court to the affidavit in opposition filed by the respondent number 128 dated 8/8/2023 from the London Council has submitted that some irrelevant consideration it has submitted that some reasons have been cited justifying the action in paragraph 4 within bracket 1. The learned counsel, however, contends that such reasons are wholly irrelevant and are not tenable in law at all. He submits that the reasons cited are not in consonance with the circular in question, which has laid down the criteria for such consideration. This court has also been informed that under the direction of one post has been kept vacant. The case of the person is liable directly considered. That we are to be standard any counsel for the respondent at the outset has submitted that the present exercise was carried out as an exceptional manner, as an exceptional case, in as much as the post in question are normally to be filled up by direct recruitment and only to give an opportunity to in-house candidates, the seats were decided to be filled up by way of promotion. And there is no vested right, and therefore there is no right vested upon the candidate to seek such promotion. He further submits that the reason of rejection are relevant as experience in the field of operation was sought for, as the posted question would require a person with such experience.
I have annexed documents to supplement.
On the Dubey accordingly submit that no case for interference is made of, and while dismissing the writ, the interim order is also liable to be vacated. Well, rejoining his subject, the Punic the learned counsel for the petitioner has submitted that apart from the fact that the reasons cited are irrelevant and experience common, the petitioner has also requisite experience
In operation.
in operation, in the field of operation, and could not have been rejected even on that ground. The rivals made by the Senate Council for the party have been due to consider, and the material would have been careful. So, Sri Dubey, the learned counsel for the respondent, may be correct in content that post in question is generally filled up by direct recruitment and only on particular occasion the same has been decided to be filled up by promotion from this court is of view that once the decision from respondent cannot now turn around and take a stand that no right has accrued on the candidate for a fair consideration of their candidate. The court is accordingly required to examine the content of the petition as to the fact, as to his claim of fulfilling the requisite qualification as given in the circular dated 13/7/2015. The state circular has specified that the educational qualification has to be graduate with LMP license and diploma in management, and there will be a preference of candidates with diploma in management. So, as regards the head of experience, the requirement was 2 years relevant experience in the concerned. It is not a dispute that the petitioner, you have the diploma also.
Yes, everything.
He is a graduate having LMP license and also has the preferred qualification of diploma in management.
Hotel management.
The claim regarding experience is also not a dispute, as the petitioner who has been substantially working in the post of what are you working?
One of the, they did this post with the
Group D post.
Group D post.
With substantially posted, substantially serving in a group D post has the relevant experience in the concerned discipline,
And a year,
namely operation.
and in 2021, they have also said that. Page 7, page 19.
The
For the same post, same experience, same criteria.
the learned counsel for the petition has also relied upon the build-up performance by the petition, which was certified by the appropriate authority, wherein all the required eligibility criteria were said to be fulfilled by the petition.
And in 21.
As on 14/7/2021.
2021. Right.
Under such circumstances, having heard the learned counsel cannot perusal of methods of record of this court is of opinion that there will be no dispute to the fulfillment of the eligibility criteria by the petition vis-a-vis the circular dated 13/7/2021. The reasons which have been set forth the affidavit cannot be termed to be relevant to the issue and also appears to be factually incorrect. It is seen that not only the petitioner has claimed to be to have fulfilled the required criteria, such claim is also certified by appropriate authority.
Even as in 2023,
in
16.3.
As would appear from materials on record under the aforesaid fact, depriving the petitioner from a consideration for promotion to state post cannot be termed to be a reasonable and justified action. According petition has made out a case. Anything
This eligibility, this has to be followed by a computer-based test. The Lordship sees at page 44. Only 2 of the candidates have been shortlisted. Since his candidature was rejected on eligibility criteria,
no, whatever later
No, one post is there.
No, yes.
In respect to the advertisement, one post is there. They consider me for
But
that, whatever test they
that
put.
would be subject to consideration
Obviously.
of passing of the CBD test. But
Obviously.
that's my lord will clarify.
Consequently, the respondents are directed to shortlist the petition and consider it for promotion in accordance with law.
In respect of the circular.
Accordance with law and the guidelines laid down in.
Can your lordship indicate that he may be called for CBD? So that is what is required. Otherwise,
That's not the issue.
The interim order stands merged because one post was kept vacant. It stands merged.
How many posts were there?
5. 4, no, 4 were filled up. 4 they went ahead.
Not filled up.
Not filled up.
Two they have.
There was an order, you go ahead with 4, keep 1 post
We
vacant.
have filled up only, we could only fill up 1.
So that is up to them. But the order was go ahead with 4.
That is not.
Obliged. Obliged.
Compassionate appointment matter pertains to the earlier he was directed to obtain instruction.
By way of a paperized comment, Lordship, I have given instruction, Lordship. In fact, the proposal has to be moved by the Lordship Director of Accounts and Treasury, Korvavan District 46, Lordship, because he is working in the account section in our department, Lordship. This is, Lordship,
But that was in 2009.
Yes, Lord. There was, we also have received from. This has not been.
Because this court, while issuing notice, has
PLC
mentioned,
has not received any proposal.
no, this court, while issuing notice on 26 4 2023, has made the following observation. Although this restriction prima facie appears to be hid by the principles of delay and action,
Yeah, Lordship, the respondent number two has to move, forward the application to the Lordship DL.
was it ever considered by the DL?
Lordship, it's not.
Was it
It was not communicated to the DLC.
Lordship.
was it filed before the appropriate authority? Subject to the authority by the-
Yes, Lordship. Please, sir, Lordship.
Because but you are for the irrigation department.
Lordship, I am for Lordship
Now
one.
he has claimed that on 24/12/2009 he had filed application for the.
Lordship.
Now was it actually filed for you?
Lordship, this is my.
No, no, tell us. Was it subject for
Lordship, this is not clear from here, Lordship, but they say, Lordship, the proposal has to be moved from the Lordship respondent number 2, Lord. The Director of Accounts, Treasury, Lord.
Director of Accounts, Treasury?
The direct respondent number 2.
Who I fight? His father was working where?
He was working in the irrigation department, Lordship, in account section, Lordship.
Okay, his department was not irrigation. It was an accounts person.
Accounts person, Lord.
Those considerations not
Applied on the same Lordship. Petitioner applied on the same Lordship.
if you applied in 2009,
Filing of this case, there are
but
no any communication, Lord.
The petitioner communicated before the irrigation.
Yes.
Yes, Lordship. He have communicated, but he was not obtained the
You
proper
waited
answer.
14 years to file a court case.
He was trying to obtain instruction from the appropriate authority, but he failed, Lord.
Will it take 14 years? 6 months, 1 year, 2 years, 14 years.
My humble prayer before your Lordship, till that Lordship application is not placed before the DLC, Lord.
Yes, that is correct. But to hesitate your right,
Then kindly direct place the application
to
before the
hesitate
DLC.
your right, you need to be vigilant. You need to be diligent. You come to this court after 14 years. Don't like to read it. Dismiss the writ.
I have applied before respondent number 2, and respondent number 2 have not placed it before the appropriate authority, Lord.
Respondent number 2 has not placed it. That is the wrong committee. But what do you do till then? Thereafter? Just cannot bank upon some action of the authority. You have to be diligent, come to the court, knock the door of the court, at least file representation to legal notice. Nothing. But we continue and it comes to the issue involved is a claim for appointment on completion of ground. The case of the petition that her husband Deepak Bora was serving as a deputy accounts officer, the office of the executive of Madhyamati Education Division, who had died on 24/10/2009 petitioner claims to have submitted an application for appointment on completion ground on 24/12, which however was not placed to the DL. Thereafter, the petition, this petition has been filed for their court while it had made issued by order date 24 2020 had made the following observation. Also, for the Upadhyay and attending of education department submit on instruction that the deceased employee was admitted a deputy account officer and the application for appointment completion ground was submitted should have been submitted.
In fact, Lordship, a paragraph 3 of the petition reflects Lordship the submitted before the national.
Who is the Yamaji?
No,
I mean the executive engineer.
no. Who is the director of accounts? Lord?
Then what do you say? It should be submitted for whom?
Two.
He has submitted for two.
Yes, sir. The application was submitted before the respondent number 2, but it was whether it was submitted before the Lordship DLC or not, this is not known. Lord.
Was submitted for the director of accounts and preservation for my account, and therefore he is not aware as to whether the same was placed for DL. Yes. Yes.
Yes.
That he has said. Can't you get instructions that what has happened to the DL? Madam? Why? Is
No
okay.
communication, Lordship, specific instruction. No communication has been received from the respondent number 2 and 4 till date. Hence, the case of the petitioner could not be placed
No,
before
there
the
is a
district
delay
level committee.
on her part. But the application at page 12, it is it has been received by the appropriate authorities. There is the format at page 13. Yes, the petitioner is definitely late in coming. It is rightly observed by the court. But
Lordship, I have the instruction.
because this court has said why to answer ascertain why as to why the application was never considered by DL. That was the
Because it was never forwarded to the DLC for consideration, Lordship. Because the concerned department has to communicate to the
let him
district level.
forward. Let him forward. Yes. If it is not, then not be proper. Yes, you are correct. At page 14, that is the form. Right. It is a horror. But the application, however, appears to have routed through the office, through the executive Hemaji division, respect delegation, and from next B, it appears that in the enclosed format, comma, the state executive engineer had forwarded this same for onward consideration.
Lordship, one more thing I want to point out, page number 13, the age of the petitioner, Lordship. This is also, Lordship, by 1970, Lordship. This is also has to be. I'm just pointing out, Lord.
See, but in August, in October 2009, he was what,
Yes,
39?
Lordship. Yes,
He
yes.
was 39.
Yes.
And I think 42 is the age. What is the age?
40, I think, some extent it is considered, Lordship, but what?
What is the age?
45.
40? 38. At that time? But at that time, definitely he was entitled.
Yes, yes. That time,
That same part of that state council has submitted on instruction, has submitted that instructions were sought for in terms of earlier order for 2020, which that reason as to why the application was never considered by the common. This would have confirmed that the application had never reached the DL for such consideration. Well, so this court had observed regarding the delay and the approach of the query of this court regarding the fate of the application has been answered by certain conflicts in the aforesaid manner that the same was never placed for the case. Under those facts, this of the that the would be met if consideration made by the jail of the case of the according to direct that the jail would consider this in its next for her claim for a person. It further makes clear that this matter has kept in hands of the authority. The factor of overage would not come the way of according to dispose of the matter in manner.
Obliged, Lord. Please.
Came for some time to file my affidavit.
What is the matter?
They are seeking a regularization.
How?
My lord, they are contractual employee of Brahmaputra board, my lord. They are working since last, some of them are working for 28 years and some are, my lord, 20 years.
Contractual employees as what?
My lord, their service are not, my lord.
What post?
My lord, they are, my lord, in mechanical, my lord.
As what? Posting as what?
All are in different,
Master role.
all are in different posts, my lord.
Master role.
Yes, my lord.
On contract.
Third PNK put the responsibility. Who has filed with a prayer for regularization of service by claiming to have served for long and continuous period. The RKD shall be considered as however subject that of the petition board was as per a contract. Would be further subject that based upon to take file an affidavit for which is done.
All right.
Please, Your Worship. This matter pertains to election by the sub-selection commission for the post of
Instruction I have received over phone, vacancy not available.
Or PR Sharma Council petitioners. How many of them are there? Two. MS Sharma.
As for
As for this is our submit that as per the reporting vacancies are not available. So the council for the response direct file
All right. But as per last Lojima court order 31/8/2023, the services of all the respondents has been completed.
complete.
Private
Service complete over. Complete.
Yes, completed. And respondent number 29 as per the prayer of the petitioner, it has been struck. We need 6 weeks time to file affidavit on behalf of.
What is the
It's a seniority matter.
your working as what?
I am working Food Corporation of India
As what?
as a
AG1 January.
You are
Assistant.
agree by your conferment of senior. The
yes,
respondents have been placed about you.
Yes.
But other matters.
Similar matter.
Similar, but different department, I mean different designations.
PK Gupta and competition in each case.
One
case which is who is active by conferment of the private above the also had six pending as per in all the cases closing orders are there.
All the
Uh, as per order passed by the closing court the service of the private is complete and respondent and the name of this for 29 as this top of
Your Lordship, in case of this 6633, that is, to see here 29 and 33, these people, they have moved out of zone, hence they are not required.
29 33
Their name has to be struck out.
here but six as per those order complete except respond numbers
29 and 30.
29 and 33 put compare the United Council for the Personality State submit that the aforesaid two respondents are no longer serving in the state zone and therefore their name may be struck off from the area of part. No, it's striking of your file. Current council may file appropriate IA for striking of the because of this system cannot now it has been that the matter be listed the biggest however this grant how much
6 weeks time.
22 months 4 weeks time to file counter this of
Kindly fix a date. That will be
this on on 13th of
16th of
16th of and other
in other two cases, Your Lordship,
29 has been struck off.
one name has to be struck off. Serial number 7.
29 phone number
7033.
7032 respondent which
Respondent Ranjit Singh. Number 7.
You have to find IA.
He has resigned from service.
As he has resigned from service. As his, and the last one 709
Same person. 7.
Number is also same.
Same, yes, sir. Your Lord.
7 as he has resigned from.
For this also I have to move application.
Yes. Yes, it's not reflected. Any correction in the memo per area of participation by means of a format.
Oblige.
Oblige.
Yes, Mr. Purva,
My lord, as per Lozima Court order dated 28/8/2033, my lord.
Yes.
Respondent number 8 and 9 already service has been completed, my lord. In respect of respondent number 2 to 7 and 10, my lord, maybe team to be sharp, my lord.
May I please, Lordship? In earlier occasion, for Brahmaputra Board, standing council was there, but nowadays, CCC will appear.
You appear, my lord, my lord. Service is completed.
you are for Madam, you are for
All
1 to 7. What?
Okay.
8 also.
1 to 8. What about 9 and 10?
9
and all
all respond.
Third. Our Purva petition who has referred the order dated of the third clause with regard of service on response either as appeared for all the order to file counter.
Pick the date matter, otherwise maybe for difficult to list it. The date. Deep level.
Wait, is the lordship. Lordship, this is a fresh contempt application. Notice needs to go. Yes. Operating party is page 69. So, sole respondent. Matter pertains to this completion appointment, wherein there was a clause.
69.
Yes, sir. Middle part clause.
This
Page 69, middle part.
silence period. Silence period.
Yes, sir. The 3 years period.
There is a appeal pen.
Appeal. Yes, clause. But it's not no stay right in front. But before the appeal was filed, this the contempt applications were filed, but not listed. But it's the third time it is in.
Third state counsel for the petition who by means of the appeal has made a complaint regarding non-compliance of order dated 27 passed by this court
518/2020. 67 page. WPC number 518.
W518 of this court has also the direct counsel referred forwarding letter dated 31 2020 by which copy of court order was forwarded to present response. This court is, however, aware of the fact that the issue involved is subject matter of challenge in honorable division. The is with regard to challenge period of service while considered case for appointment. Either is that written by court that step take step by
Similar matters 45 and 46.
for it judgment is
45 judgment dated. Is
how many
first one petition.
45 dated
1646. The main judge 1646 2021.
1646 of
Judgment date is lordship 31/2023. 31 page 34.
31 WPC
WBC lordship is 1646 stroke 2021. 1646.
and forwarding that
Forwarding letter dated 13 February 2023. 13 February. So respond.
and the
Other one lordship page item number 46.
Judgment
Correspondence. Forwarding letter dated.
judgment dated
Judgment dated 24 to 2023, page 68.
24 to
2023.
2020. And in WPC
1154 stroke 2022.
1154 of forwarding that
Dated 1/3/2023.
monthly. 6 steps per month.
Oblige.
Lawsuit. New matter.
New matter. Earlier two occasions it was discussed, but the matter could not taken up. Page 16 is the order.
What is the matter?
This compassionate effort petitioner has applied. It was forwarded to the Deputy Commissioner, CASA, but it was not being placed.
No, what was the order?
Lordship, page 16 may kindly pay the direction was issued. To the page 17 is the operative part. In view of a limited demand space, we direct the Deputy Commissioner, CASA,
Okay, we have L order it 16 12 2020 WP 808 2020 operation representation dated 23 12 2020 so forwarding. Okay, except for
May I please, your Lordship? Lordship, this is a fresh matter. It's a condemned petition which is arising due to non-compliance of the order dated 14/12/2022 passed in WPC number 8005 of 2022. Madam. The directive portion is at page number 10, madam. Remember that the petitioner has applied for transfer, madam, but the representation through which he has applied for was not considered, madam.
there is the direction for consideration.
Yes, madam. Within a period of 1 month, madam, from the receipt.
Order dated. Your name? Ego.
PH4, madam.
PH4. PH. Order dated 14/12/20. WP 8005. Option. Where is your forwarding?
Page number 12, madam.
Forwarded by what is 13?
Madam,
Your application forwarded by 1912. Yes. Next step by Monday.
Deeply obliged, madam.
Confirm.
Lordship, I am intended to get full pension, but I have been paid lower pension by deducting 17 years of service period from 41 years.
Where is the order? Where is the order?
Order Annexure 1,
Page
page 14,
40.
14.
Your name?
J. Tamuli.
J. Tamuli. Order date 9/20. 4414. Where is your forward?
Annexure 2, page 90 to 37.
Forwarding letter 7/9/2020. I issued notice to accept by Monday. Registered proceedings.
What are these space 14 like this? Relevant part is the 14 words. Four and five.
K.D. Sharma.
Then my
Order dated 21/9/2022. Deputy I-170. Where are the forwarding?
forwarding at page 15 Lord.
1/5. Was it considered or not?
Not considered SLC seated but not recommended due to 5% of quota lordship. That is in excess 16 lordship.
That's not a content.
No, there's direct on lordship to
But it's a content. We are only concerned with whether it was the order was complied with. Order said considered.
order to consider Lord.
They have considered and rejected. You have pressed. You have challenged it. This court has, however, the petition accept as, however, where is the consideration?
Page 16 Lord. Type copy.
Date
Meeting held on 2/3/23 Lord.
Type copies were page.
Page 16 Lord. Exactly. Type copy.
The petition has, however, annex a minus of meeting on dated 2/3 where the case of the petition was indeed considered, but however could not be run completion department to want of vacancy. Concern in the opinion of such consideration would not amount a willful and deliberate disobedience of any of the order of the court. Therefore, will be put to challenge to question the correct of the decision of the alleging contempt is held and according to truth.
May I please the Lordship? Lordship, can you have a look on the order dated 7/6/23 my Lord? This honorable court my Lord.
Yes.
Yes, my Lord. The last paragraph, my Lord. That is the petitioners to take steps for the issuance of notice upon the private respondent so and so by way of registered post to AD within 10 days. The petitioner are also permitted to serve notice upon the private respondent so and so through respondent number 4, my Lord, by furnishing the copy of the petition along with the order passed today. After effecting such service, an affidavit be filed by the petitioners in proof thereof, and respondent 4 shall serve the copies upon the private respondent number 5. My Lord, in the light of this, when the order, my Lord, we have served copies, and accordingly, my Lord, we have filed service of notice that we have served copy to the respondent number 4 for the respondent 5 to 9, my Lord. We have filed affidavit. But till date, my Lord, the respondent number 4, my Lord, no affidavit has been filed there so far as whether how he has taken steps to the all the private respondents, my Lord. According to these matters posted before the Lawazima court, my Lord, on 24 August, my Lord.
Yes.
And 24 August, my Lord, and so far as the service of the respondent 8 and 9 is concerned, my Lord. Altogether 5 respondents, and out of this 5 respondents, 3 has already been, we have received information that 3 has already been joint service, my Lord, and respondent 8 and 9 not yet joined, my Lord. My humble summary at this, my Lord, at this stage. since respondent four is not responding yet, my lord, and there is some urgent in this
Who is
matter.
for,
Principal cum superintendent of test school, Hospital Medical College, my lord.
are you representing that? Health department?
And delaying this process, my lord. And my humble submission, my lord.
We'll have the response.
Yes, my lord. Lordship, kindly, my lord, give direction to the respondent four as well as government also file the affidavit and takes this for admission.
We'll have this on Monday. To data is available, is present along with that of, along with present, along. Yes. Go put. It is only on the stage of step. You are to serve certain respondents.
Yes, sir.
Have you served them?
Yes, my lord. But that specific instruction, my lord.
Do you have the instructions? We'll have it on Friday night.
Yeah, that will be.
Yes, my lord. Yes.
How many petitions? One.
My lord, four.
Petition. However, a week to update instructions which regard service upon by the based on
Next week, the lordship.
next Friday.
Friday.
Deeply obliged. Deeply.
That's when the last occasion we were asked to bring specific instructions regarding the after the pollution of the thing. So there's an order which has been passed. I think now the statutory powers and administrative powers are accessed by the divisional.
Regarding Kaupura's appeal,
Yes, sir.
we have to dispose of
Yes, sir. The day before the.
Same.
did you file the appeal?
Sir, I filed.
File the appeal.
Appeal is pending.
Now
at the time, commissioner was abolished.
Yes, filed before the commissioner.
Understood. Now the powers have been vested.
Exactly. So, my lord, now he can approach the commissioner because that time he approached the divisional office. My lord. Now he should go to the commissioner and secretary GH.
All appeal.
All will close this.
No.
We'll give you liberty to close the and so since you have filed your appeal this time, the period of
Already sent to the commissioner of GAG.
you just to facilitate the expedite you serve another
Just appeal.
press copy. Press copy. The same appeal. Third for the petitioners.
Petitioners, 9 petitioners.
Petitioners are who are aggrieved by aggrieved by a selection process for the post of now various blocks of committee. The petition. There are many
Different
blocks.
I enclose one appeal here. One. Petitioner district.
Petitioner preference big damage of act of the case that they had appeared It is held on pure in the office of deputy wherever considered of the not thereby described where the additional alleged gross anomaly such as for the additional for the to have for the computer of not which were not taken up for consideration. Therefore, the president was filed. All thirds
If respond ma'am. General administration.
TAT for general whereas has also has appeared for the department and secretariat. And the have however that so that the fact that the appearance of that is a thing the appearance from division and function to the simple secretary to the
Commissioner and secretary.
commission and secretary public the state and 7 is on record. This would that that and man did not cause back. This would that without the private but the following which was the state the petition this would was direct copies of every that this could direct the present capital name the commissioner to take the epic concept and it put the and put it after the of it from the this that while assessment the effect stakeholders the effect part and output further to facilitate assessment the direct certificate of the present capital also clarify that this where earlier appeal was within time this earlier appeal were that time the question but I consider not and
Not district is Biswanath restaurant, lesson right there, plus 24. District is Biswanath.
law city
Biswanath.
here written a copy of the order 7 notification 7